We had the ghost gun bill.
I know, I saw that, I was watching. Or
Oh, were you?
paying attention.
Okay.
No
We did?
comment.
We, on the ghost gun bill? Yeah, I thought so too.
I have no doubt.
I should say evening, everyone, but good evening, everyone. Today is Thursday, March 10th. We have 9 bills on the docket. We'll start off with Senator West with Senate Bill 849. We'll then move to Senate Bill 718, 820, 772, 889, 762, 750, 666, and 884. So with that, Senator West, the floor is yours.
Thank you, Mr. Chair. It's a pleasure to be here to present Senate Bill 849, which, by the way, is my final bill of the year. It's certainly not the least of the bills this year. This is a rather important one. Under Maryland law, the courts resolve child custody disputes based on the determination of what is in the child's best interests. The courts determine best interests by a series of factors, including parent fitness and reputation, child preference and health, as well as separation length and opportunity visitation. Traditionally, when one parent was granted custody of a minor child, the other parent would generally be awarded visitation rights. In 1984, the Court of Appeals first recognized and applied the concept of joint custody. The ruling explained that within the meaning of custody are the concepts of legal custody and physical custody. Legal custody is defined as the right and obligation to make long-term decisions involving the education, religious training, discipline, medical care, and other matters of major significance concerning the child's life and welfare. Physical custody means the right and obligation to provide a home for the child and to make the day-to-day decisions required during the time the child is with the parent having such custody. Senate Bill 849 alters provisions of law relating to child custody and visitation proceedings and establishes numerous factors for courts to consider in cases involving legal decision-making and parenting time. The terms legal decision-making and parenting time are new terms which are analogous of the old terms legal custody and physical custody, respectively. The bill also establishes that the court may award legal decision-making or parenting time to one parent or jointly to the parents. No parent is presumed to have any right to legal decision-making or parenting time that is superior to the right of the other parent. The bill also specifies that a parent is a biological parent, an adoptive parent, or an individual whom the court has deemed to be a de facto parent. Finally, Senate Bill 849 establishes a new subtitle which lists in great detail the various factors for judicial consideration in cases involving legal decision-making and parental responsibility. The purpose of the provisions includes promoting stability and long-term health and welfare for children by specified methods, providing children with physical and emotional security and protection from exposure to conflict and violence, and providing for an expeditious, thoughtful, and consistent process for decision-making by courts to protect the best interests of children. This bill is a comprehensive addition to child custody decisions, which will further ensure the safety and prosperity of young Marylanders with separated parents. There's no one that I know of who's better qualified through experience and interest to discuss the provisions of this bill than Judge Kathleen DeMay, formerly Delegate Kathleen DeMay, whom we all know.
Thank you. Thank you, Senator West, for that nice introduction. Good afternoon, everyone. It's nice to be back and to see everyone. This bill I have presented before, and it's legislation that is the result of a Commission on Child Custody Decision-Making that was established by the General Assembly in 2013 and was tasked with discussing or looking at how we make these custody decisions. The commission actually had about 30 members, but we also broke down into, I think, 6 subcommittees, and we invited people into the subcommittees, so there were probably over 200 people overall involved in the commission that sort of worked this through. One of the subcommittees worked on this statute, which you have before you today. And the idea behind the custody statute is to provide a clear, predictable, and consistent guide for parents, lawyers, and the courts. As you know, I'm now sitting on the bench, and I actually have heard many custody cases since I started on December 3rd. And it would be very helpful to be able to point parties lawyers, and some of my colleagues on the bench in this direction to say these are the factors. Where these factors come from, there are two cases in particular, although there's lots of cases, but two in particular in Maryland. Taylor v. Taylor, that talks about joint legal custody and lists a long list of factors to consider it, or legal custody to consider. And Montgomery County v. Sanders, which is actually was sort of a Senate case, but has a long list of factors. And that's the two cases we always quote. But what this commission did, and the subcommittee that looked at the statutes across the country. And although the factors from our cases are included, so are factors that we thought were important from other statutes. The other thing this commission did that has been very helpful in custody cases, there was a court process committee that actually, the result was the development of Maryland Rule 9-204.1 and 9-204.2, which requires parties and litigants to submit a parenting plan, which they can look at. Some of these factors are included in the rule now, and each party has to submit a plan of here's what I think the access should be, or here's what I think how we should share holidays. But perhaps the most important thing about this bill is it's trying to change the dynamic and the nomenclature. I've always hated the word visitation, and I don't use it. Didn't use it in my practice, and I don't talk about it on the court, because I don't think any parent visits with a child. So what this is trying to do is change the dynamic and talk about parenting time. One party has parenting time for these days, one party has parenting time for these days at these times. And we also want to, instead of say somebody has legal custody and the other doesn't, now we want to talk about decision-making authority. And again, it's, can be, you can divide decision-making authority, divide it where one parent has more authority on education issues, one on medical, or they can just share it and have joint decision-making authority. So I think this will change the dynamics. It's already doing that since the parenting plans have been in place. Many of us that are aware of this are using this nomenclature, and it's what I was using in my agreements before I went on the bench. And it's the conversation I have with litigants. During the time that I've been on the bench, I would say half of my cases have been self-represented litigants who have custody cases. And being able to say, here are despite the fact the parenting plans are there and they're supposed to submit them, that doesn't always happen. But to be able to sort of say, I want you to look at these things, these are what I want to consider. And although it's important to know sort of what's in each household, it's also important that we focus on the child. What's best for the child? And I think this statute does that. It makes it a child-focused process. So the House passed this bill last year. I testified this afternoon virtually, sitting in Senator King's office, on the bill this afternoon. I hope they pass it. I hope that you will consider passing it. We just ran out of time last year. It's been sort of a long struggle, and we've tweaked things as since the commission finished in 2015 or 16. But I do think it's a very solid product, and it would be a wonderful addition to our statutory scheme. Happy to take questions. Do you do that at the end? Okay. Absolutely fine. Whatever this jurisdiction would like. Even this?
Good afternoon. Lindsay Parvis. I'm here on behalf of the Family and Juvenile Law section of the Maryland State Bar Association in favor of Senate Bill 849. And I won't repeat what Judge Dumais has shared, nor what is in our testimony, written testimony that we submitted. I just invite this committee to consider that from an access to justice perspective, passing this statute will provide a central place for parents to be able to access critical information for putting on their cases, especially when so many of these parenting rights, parenting responsibility cases fall to self-represented litigants. I also, and a large part of my practice is representing children as court-appointed counsel. And what I can say is that the language changes in this bill alone would be an important shift in policy change toward moving away from language that is possessory with respect to children, as if they are possessions when we speak of custody, and instead shifting to what is so such a more accurate description of what it is that courts are called upon to decide for these families, which is parenting time and legal decision-making and parenting responsibilities. So this shift is so important, and we therefore ask for a favorable report. Thank you.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. My name is Dorothy Lenig. I'm the Director of the Domestic Violence Legal Clinic at the House of Ruth. We urge a favorable report on Senate Bill 849. I'm also here on behalf of the Women's Law Center and the Maryland Network Against Domestic Violence. They took the House today, I took the Senate, and I'm just going to say me too. So thank you.
All right, excellent. Questions from the committee? We're all beat from a floor session, so.
I understand
yeah.
completely. Okay, well,
All
thank
right.
you. If you
Well,
have
thank
other
you all.
questions afterwards, anyone feel free to contact me. I'd be happy to talk.
Excellent. We'll look to take this up next week, Senator
Okay.
West, so we'll be in touch.
Great.
Thank you.
Thank you.
All right. With that, I think that ends the hearing. Unless there's anyone else I forgot, that ends the hearing for Senate Bill 849. We'll now move on. Is Senator Simonaire still here?
He's on his way.
He's on his way. Here you are. There he is. Senator Simonaire, you're up. Senator Simonaire with Senate Bill 718.
Thank you, Mr. Chairman. It's great to be before this committee. I served here many years ago for 4 years. Anyway, I'm here on Senate Bill 118. One of my constituents approached me about alimony and how Maryland law treated it versus other states. And it was interesting as I researched the topic. My understanding is generally when a spouse remarries, the alimony is terminated. The problem was brought up when a former spouse receives alimony and they are living with someone else as if they were remarried. They still have to pay alimony because they did not legally marry. An example, a former spouse lives with someone, shares expenses and everything else. Maryland law doesn't specifically cover it because it is not officially married. Maryland law is very vague, saying it can be modified when circumstances or justice require it. This bill simply adds language giving a framework to have the judge consider this type of situation. It is not a mandate. Other states have this provision, and this bill was modeled after the Massachusetts law. We didn't want to make it so prescriptive as other states have done with saying you have to be 3 months or 6 months. We left it up to the flexibility of the courts. I've seen some of the testimony. We're willing to amend this if you see fit, but I'm just going to let my constituent talk more about it, and I would ask for a favorable consideration.
Excellent. Thank you very much.
Thank
All
you.
right. Ryan Stewart, you're up.
Good afternoon, committee. Appreciate the opportunity to come here before you and be able to present this. Here I stand, 3 years into a divorce, and I have been put under an alimony situation where my ex has basically from a month before the order been in a cohabitation process known to the family, but you cannot bring it up. There's no way to be able to address it. There's no remedy under law. We can't bring it up. They can't raise the issue. They won't even consider it as an income. And that's what we're asking. Open it up to us so that we have the ability to be able to step back in. Yes, I read part of this memorandum that came out here from the committee. And in the memorandum, it brings up 2 issues that you say are problematic. The hearsay. The judges can control that. They can control whether or not it's hearsay. This also presents a privacy concern of third party. Here in this state, you guys, the law has went after a rehabilitative alimony instead of a forever alimony. And what basically has happened is there's no way, the judges have no way to actually go back and monitor that the person is actually rehabilitating themselves, which leaves it to the third party. if it's rehabilitative, what's the responsibility? Who has that responsibility? Who is going to be able to monitor that person and make sure that person is actually coming back and rehabilitating themselves and not making themselves become a dependent person, either on the state or on the party that has the obligation? The other thing that was brought up in here is about children. This doesn't have anything to do with children. This has everything to do with two adults that are in an agreement. It's not a mutual agreement. It's an order that's been passed down by a judge that's told them that they have to comply with this for that person to be able to do it. It has nothing to do with children.
I see the Senator West. Did you have a question?
Thank you.
Yeah.
Actually, I did. So the State Bar Association, Family and Juvenile Law Section has filed an opposition. And they state in the opposition, they say, as currently written, Section 8-103 of the Family Law Code, the court already has the authority to consider, among a multitude of other circumstances, whether since the entry of the initial agreement, the recipient now maintains a common household, and as a result thereof, circumstances in justice require modification to the agreement or settlement. Did you have an attorney representing you when you were going to court?
Absolutely.
Okay. Did the attorney discuss this section of the code with you?
So as I understand it, the current law, as it currently is written, there are decisions that have been made where that if you come through a separation agreement,
Mm-hmm.
and it is agreed upon by both parties,
Right.
it can be incorporated that if cohabitation exists, that it ceases. I think it's the Gordon versus Gordon case.
Yeah.
That it ceases that responsibility of alimony. But when you come back to a party who actually has gone through, and it is a conflict, or, high conflict divorce, where that neither party agree, it comes down to a judge's order. And so when it comes down to a judge's order, the judge's order then dictates exactly how that happens, and it closes the door to any kind of modification with cohabitation. It's closed.
Okay.
We don't have a remedy to it.
Thank you for your answer.
Okay, further questions from the committee? All right, thank you very much, sir. Thank you.
I ask for your support,
Appreciate
please.
it.
Thank you.
All right, with that, thank you, Senator Simonero. That'll end the hearing for, actually, I'm sorry, we have one more. Ms. Parvis, you're up. Good to see you again.
Thank you very much. I'm here again on behalf of the Family and Juvenile Law Section of the Maryland State Bar Association in opposition to Senate Bill 718 as written. What I'd like to point to, going beyond what's contained in our written testimony, is that this bill applies to Family Law Article 8103, which has to do with, strike that, with 11107, which has to do with modification of alimony. In fact, this bill doesn't even apply to the separate statute that has to do with termination of alimony, just as a distinction. And the other thing that is concerning about Senate Bill 718 as written is that it doesn't actually make clear the types of relationships that could be considered. And in reading the language of this bill as written, the triggering event is if the recipient is maintaining a common household by sharing a primary residence together with another individual, right? And so that can apply in many different circumstances, none of which are romantic, cohabitation in marriage-like relationships, which is what, for example, the Gordon v. Gordon case, which already came up, speaks to. And what I am surmising is the intent of this bill. Instead, you can have multi-generational families who live together, where this may be the circumstances, but modification of alimony may not be at all appropriate. You could have circumstances where there are housemates that are not romantically involved. You could have adult children and their parents residing together. This could be triggered and therefore be an opportunity for delving into the financial circumstances of that third party. With that, I would ask an unfavorable report. Thank you.
Excellent. Thank you very much. Questions from the committee? All right, seeing none. Thank
Thank
you.
you.
Have a good one. And with that, that'll conclude the hearing for Senate Bill 718. We'll now move on to Senator Lamb, who's back with Senate Bill 820.
All right, thank you. Committee asked Mr. Adler from the Office of Legislative Audits to come up as well to be on the witness panel. I think you're informational only, so for questions. So good afternoon, or almost good evening, Chairman Smith, Vice Chair, and members of the committee. For the record, Clarence Lamb, Senator in District 12. The purpose of SB 820 is to require a local Department of Social Services that fails to conduct a child abuse or neglect investigation within the required time frame to report the delay and the reason or reasons for that delay in a timely manner to their supervisor. The local Department of Social Services would also be required to report annually to the Maryland General Assembly on the progress of the local department's compliance with the statutory timeframes of conducting investigations and completing these reports. This bill stems from an unfortunate long-standing problem within the Department of Human Services and its ability to properly track and complete child abuse investigations in a timely manner. We understand that there are significant concerns relating to staffing and resources within our local social services departments, and this bill is not meant to denigrate the tremendous work that so many of our social workers and law enforcement entities are engaging in order to protect the welfare of Maryland's children. This bill is meant to provide the General Assembly with more regular insights as opposed to periodically scheduled audits to inform future policy proposals and to strengthen our state social service infrastructure. The Joint Audit and Evaluation Committee has received repeated audit findings over the last 5 years regarding the timeliness of completed investigations of child abuse and neglect, which has compelled the need for this legislation that I'm bringing forward to this committee today. As the Senate Chair of the Joint Audits Committee, we most recently heard concerns pertaining to this issue just last year. And to be clear, this was not the first time that we've heard concerns from our Office of Legislative Audit auditors. There were several members of the Joint Audits Committee when we last heard this late last year, whom expressed significant concerns as it pertains to the safety and well-being of our children. And that's why, as the chair of the committee, I'm bringing forward this bill today in an effort to help address some of the timeliness of this investigative reporting. As I'm sure this committee is aware, the local Department of Social Services or local law enforcement must attempt to see a child and decide on the safety of that child within 24 hours after receiving a report of suspected physical or sexual abuse and within 5 days after receiving a report of suspected child neglect or mental injury. And to the extent possible, a child abuse and neglect investigation must be completed within 10 days after receiving the initial notice of suspected abuse or neglect. On November 20th, 2017, the Joint Audits and Evaluation Committee was told that the DSS did not monitor the timeliness of child abuse and neglect investigations initially. In June of 2019, we were told of numerous local Department of Social Service deficiencies related to critical social service administration policies, including child and adult protective services and out-of-home placements. Again, there were issues with the local social services department not filing reports and or monitoring them. And then finally, this past summer, in June of 2021, we were told that social services monitoring processes were not effective for both ensuring the timeliness of child abuse and neglect investigations and for the required assessments of substance abuse exposed newborn mothers. In our written testimony, we have provided a link to you for the full 2021 OLA audit report. This bill will require that the local Department of Social Services who fail to conduct an investigation of child abuse or which fail to complete a report in the assigned timeline to document, track, and report on delayed investigations. The bill retains all the current statute requirements for various forms of child abuse reports. However, under this bill, as proposed, the local department or the appropriate law enforcement agency shall report any delay and the reason of the delay to the supervisor. They should also maintain a record of the delay and the reasons for the delay in the child's case file, and also require the supervisor who received the report to review and sign it. Finally, DHS will be required to report to the General Assembly each year on the progress of the local departments complying with these timeframes for completing these investigations and the subsequent reports under the current statute. We understand that the department is dealing with many issues, and many of those come down to lack of resource and support. This can make meeting these deadlines sometimes challenging. But with the population involved, particularly with children, it's our obligation to make sure that they are well protected. These departments are statutorily required to meet the investigation requirements, and unfortunately, they have fallen short based on our auditor's findings. We have been in communication with the related stakeholders to draft some amendments, including the National Association of Social Workers, the licensed professional counselors of Maryland, and the Department of Health to ensure that the bill's intent can be strengthened. There is one amendment, and that would authorize licensed professional counselors to perform these abuse and neglect investigations, and another amendment that was requested by the Department of Human Services itself to sunset the bill after 5 years, which we have accepted as friendly, and recognize that it's within the bill's intent to leverage this collected information to propose future legislation if necessary in upcoming sessions. So as a member of the Joint Audits and Evaluation Committee as the chair, I have great respect for our auditors and also thankful for Mr. Adler, who's here to provide informational testimony. They have reiterated that there are many gaps within the investigation process that might have been discovered by social services and the local department if an active monitoring process had been in place. Children with reported instances of abuse and neglect against them represent the most vulnerable populations of this state. And while this may not directly solve the problem of child abuse and neglect and prevent it from occurring, it will add to our statute a more robust oversight process for why delays in investigations are occurring, ensure that this concern, which has come up in repeated audits, is not lost in the shuffle, and allow the Joint Audits and Evaluation Committee to continue monitoring the issue as well as laying the groundwork for future legislative action. And with that, let me close and ask the committee for positive consideration. Happy to answer any questions.
Sure, you want to take the, we'll take questions at the end of the panel. Ms. Adler, if you want to come on up, and then we'll take questions.
Good afternoon, chairs and committee members. Good afternoon, chairs and committee members. My name is Josh Adler. I'm an assistant director with the Office of Legislative Audits, and I'm one of the people responsible for the audits of the Department of Human Services, Social Services Administration, and SSA. I'm here today to report on our audit findings noted in our two most recent SSA audit reports dated June 2021 and November 2017, which covered the period January 2013 through April 2020. Both of the aforementioned SSA audit reports include findings which highlighted that investigations related to allegations of child abuse and neglect weren't done within the timeframes established by state law. For example, on our June 2021 audit report, we noted our test of 20 allegations of child abuse and neglect, that 6 weren't done timely in terms of when the investigations happened, and of those, 3 of them weren't done timely in terms of when the investigations were completed. State law requires, as Senator Lamb said, state law requires investigations to be state law requires the investigations of neglect to be done within 24 hours, and investigations of abuse to be done within 24 hours, and investigations of neglect to be done within to be started within 5 days, and they both have to be completed within 60 days. I'd also like to add that the issues noted here are not documentation or are not computer system deficiencies, and as has been reported by the department in other hearings. Rather, it boils down to people that are not doing their job as they're supposed to. If I may be so bold to quote the chairman of the Joint Audit and Evaluation Committee, Senator Lamb, who said, if it's not documented, it wasn't done. I think that would be OLA's position as well. With that said, in accordance with long-standing practice of the Office of Legislative Audits, we can't take a position on this on the specific legislation. However, it does note that the requirements of the legislation appears to have relevance to our audit findings, and specifically, this documentation will certainly strengthen the compliance with the statute as it exists right now. On a personal note, I've been doing these audits for a good long time, and I really appreciate all the hard work that the department does and law enforcement does, and I'm prepared to answer any questions you may have.
Sure, so we'll take questions for the sponsor panel. I think we have one more witness, so Senator Carter, no. Anyone else? Seeing none, thank you both very much. We've got one more witness, and that is Scott Tiffin.
Thank you, Mr. Chair and members of the committee. My name is Scott Tiffin, and I'm here on behalf of the National Association of Social Workers, as well as the Licensed Professional Counselors of Maryland. We strongly support the bill. We believe that timeliness in child abuse investigations is extremely important. In particular, the social workers are primarily the first responders, so to speak, of all of our child abuse investigations in the state. Mostly just wanted to highlight a couple amendments that are in our written testimony. One Senator Lamb already spoke about, which is to include licensed professional counselors in the list of providers that can do the mental health assessments. We just see this as just a modernization. I'm actually fairly certain this statute existed before LCPCs really existed in the state of Maryland, or at least on a large level. And then the other amendments are a little bit more substantive, or from the social workers. The one that's in the uncodified section is to try to push the department to do a workload study. Historically, the workload of child welfare workers is always documented by caseload numbers. They just count the number of kids you serve, divided by the number of workers you have, and that's all you really know. But that doesn't necessarily always capture the amount of work that folks are doing, because different kids have different needs, different levels of responsibility, different levels of work. So there's a growing emphasis among experts of doing these workload studies that really gets down to the much more detailed level how much work is being done. In the 2021 budget, there was a requirement that DHS does a workload study. DHS did not complete that workload study, saying that there weren't published standards on how to do such a study. The Child Welfare League of America is working on those standards, but in the meantime, they actually recommend looking at the standards used by other states in order to develop state-specific methodology in order to do your own workload study in your state. So in our uncodified language, we identified several states that have done this already, hopefully to help the department identify a methodology that could be used here in Maryland. Because truly, if you ask any social worker in our DSS offices, the number one reason why these reports are delayed is staffing. And unless we address the staffing issues, we're not going to get to the bottom of this issue. The other amendment we're still working on with Senator Lamb, just to provide the level of accountability that the committee is concerned about without necessarily requiring things that are outside the normal stream of work. So we're still working with his office on that language. Hopefully have something figured out in the next couple days. Otherwise, I'm happy to answer any questions.
Excellent, thank you very much. Well, once you all figure out the language, please be sure to get it to our council so we can start working on it next week.
Thank you.
Excellent, thank you. Questions from the committee? Seeing none, thank you all very much. All right, so with that, that'll end this bill hearing for Senate Bill 820. We'll now go on to Senator Carter with Senate Bill 772.
Good afternoon to the hardest working committee in the Senate of Maryland. I'd like to bring up my panel. My panel is Natasha Kalfani, Stephanie Glaberson, and Rebecca Stahl. Mr. Chairman and members of the committee, this is a bill that I think is very much in line with our efforts around ending marijuana prohibition. We've gone through incrementalization from decriminalizing small amounts till now looking at potentially legalizing recreational use, followed by our legalization of medical marijuana. Yet there's still a problem when it comes to certain parents that are in the system when it comes to their custodial rights as parents. And so this bill seeks to address the problem. I don't think that we can allow parents to be harmed in the process of having access or custody to their children because of marijuana use when we are looking at ending prohibition altogether. And so what this bill does, Senate Bill 772, alters the definition of neglect in statutory provisions that govern child in need of assistance proceedings. The bill specifies that except under certain circumstances, neglect does not include the use of marijuana by any parent or individual who has permanent or temporary care or custody or responsibility for supervision of the child. In 2017, 651 children nationwide were placed in foster care because of parental drug use. Among that number were children whose parents used only marijuana. While typically not the only issue when children are brought before the court in Senate cases, marijuana is generally used as additional evidence against a parent challenging their ability to care for the child. However, far too often, for many parents, marijuana can be the sole barrier to them regaining custody of their children. Even for parents who have been determined by the court to have successfully addressed issues of parenting, mental health, housing, etc., a positive toxicology report for marijuana could be the sole basis for preventing reunification. It's important to separate cannabis use from allegations of abuse. The two are not synonymous. There is no science or evidence to support that family separation based upon parental marijuana use alone does not predict parental deficiency. The use of marijuana as evidence of neglect only contributes to the racial discrimination already widely perpetuated in the child welfare system. While the data is not available in Maryland, it is understood nationally that, like so many issues involving child welfare, people often are treated differently due to their race when it comes to parents who use marijuana. In an article published in the imprint, it was reported that white and well-to-do parents have publicly testified to the calming effects of marijuana openly, participating in groups like Moms for Marijuana, while Black and Latinx parents are often held to a different standard, finding themselves accused of being unfit to raise their children if they use marijuana, even occasionally. States like Texas, New York, and Massachusetts have already passed laws like this, affirmatively stating that a parent may not be found to neglect their child on the sole basis of marijuana use. Maryland needs to do the same. The law should reflect that the use of marijuana by itself is not evidence that a parent is unable or unwilling to care for their child. While case law already exists that states that there must be a nexus between drug use and the risk of harm, the way parents who use marijuana are treated in the child welfare system vary across jurisdictions in Maryland. Having a statute that explicitly states that marijuana use alone does not mean a parent is neglectful will better align with the child welfare law, with what we know to be true about marijuana use. That it alone is not a nexus to abuse or neglect. This change in the law would also serve to align child welfare with the decriminalization and social acceptance of marijuana use in the state and nation at large. For all of these reasons, I am asking this committee to give a favorable report to Senate Bill 772. Thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members. Thank you for having me. My name is Stephanie Glaberson, and I am a Maryland resident, voter, and parent. I'm also the visiting professor and director of the Civil Litigation Clinic at Georgetown Law, where I research and write on topics related to today's bill. I also previously worked as an attorney in New York, representing more than 100 parents in child welfare proceedings, many of whom faced marijuana-related allegations. I'm here today to urge this committee to issue a favorable report on this bill. As Senator Carter just highlighted, it is a necessary measure to begin to narrow the doors through which racism and bias enters into child welfare decisions. It is not news that the child welfare system disproportionately surveils and breaks up families of color and poor families. I have seen in my own practice and heard from Maryland practitioners how marijuana allegations in particular disproportionately affect families of color. First, the evidence shows that Black and white populations use marijuana in equal numbers. Yet, for example, Black women are 10 times more likely to be reported for investigation as a result of prenatal drug use, even though the evidence shows that white women use substances at higher rates while pregnant. So families of color wind up facing allegations of marijuana use more frequently. And once those allegations are in a case, they often become the allegations that follow parents the longest. They become an entry point for racialized bias and shift focus from where it should be, on child safety. Even where marijuana use may not be the core of an initial filing or the reason for a removal, It often becomes the reason to deny visits, to refuse to expand visits, or to deny reunification, even when there are no other remaining safety concerns. In my experience, the system winds up insisting on total abstinence, even when we know that a drug test is not a parenting test. It is possible to responsibly, therapeutically, or recreationally use marijuana and safely parent children. Given this context, this bill really is the floor. It is no more than a clear statement of what the law already must require, that to intervene in a family, there must be a connection between any alleged parental conduct, like drug use, and a risk of harm to the child. But it is still a vital and necessary statement from this legislature, especially as Maryland moves towards legislation. For these reasons, towards legalization. For these reasons, I respectfully ask that you issue a favorable report. Thank you.
Good afternoon, Mr. Chair, Vice Chair, and members of the committee. My name is Natasha Calfany. I am an attorney at the Office of the Public Defender. I represent parents whose children have come before the court for allegations of abuse or neglect. I am testifying in support of SB 772, and I would like to share the experience of a client whose marijuana use unnecessarily and unfairly prevented her from reunifying with her children. My client is Ms. B, a single mother of 6. To financially support all of her children, Ms. B would at times leave the older children to care for the younger children while she would go to work. Consequently, she came to the attention of the Department of Social Services due to a lack of appropriate supervision. She lost custody of her children. The younger 3 children were placed in the custody of their father, while the older children were placed in foster care. During the department's investigation, it was learned that Ms. B smoked marijuana. There were no allegations that she smoked in front of her children or that her marijuana use negatively impacted her parenting. Nevertheless, Ms. B was required to complete drug treatment in addition to other services. Ms. B eventually improved her situation and was ready to receive her children. She has successfully completed all services except for drug treatment, which she was continuously participating in. Although all of her children were now preteen and teenage and desperately wanted to return to her care, and 2 of the 3 were declining rapidly in every way in foster care, Ms. B continued to test positive for marijuana, even though she was in treatment, and as a result, her children were forced to languish in care. Ms. B would eventually get 2 of the 3 of her children returned to her, the third opting to go with her father, who showed up 2 years after the case started. This bill would have allowed Ms. B to reunify with all 3 of her children, rescuing them from the months and even years of devastating impact that continuing in foster care caused them. Unfortunately, Ms. B's story is not unique, and for these reasons, I urge you to submit a favorable report for SB 772. Thank you.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, and committee members. My name is Rebecca Stahl. I am the Executive Director of the University of Baltimore Sarah and Neil Meyerhoff Center for Families, Children, and the Courts. I represented more than 1,000 children in child welfare cases in multiple jurisdictions. I have written a book and articles on trauma and the role of lawyers for children. I was also a Fulbright Scholar studying the role of lawyers for children. I urge a favorable report on SB 772. This bill should not be controversial. It clarifies what is already the law, but those of us who have practiced in child welfare know the law is not always followed. Removal from a parent is one of the most traumatic experiences a child can have, even if there is a valid reason for the removal. Removal without a valid reason is even more harmful. The types of ways that trauma manifests more often in foster children are too copious to explain in 2 minutes. But the most egregious are that children are more likely to have worse educational outcomes, they are more likely to end up in the juvenile justice system, and they are more likely to be unhoused. Further, the effects of the trauma and toxic stress from removal are often misdiagnosed as mental health disorders because there is no diagnosis for toxic stress or trauma. And foster youth are therefore more likely to be prescribed unnecessary psychotropic medications, including multiple medications at once. Finally, when young children are removed from their parents, the stress-based impacts on their brains can be, and often are, lifelong. Frequently, children are removed or not returned to their parents solely because that parent tests positive, even if the parent's use was not around the children, or if the use did not cause harm to the child. Children are often prevented from reunifying with their parents who test positive, even when the initial finding of neglect and removal was unrelated to marijuana use. Children are not removed from their parents every time their parent has a glass of wine, nor should they be removed simply because a parent tests positive. SB 772 is necessary to ensure children are not subject to the trauma of unnecessary separation from their parents. For these reasons, I urge you to support SB 772, and I thank you for your time and consideration.
All right, thank you very much. We have a question from Senator Watson.
Thank you, Mr. Chair. I guess I don't agree with the characterization that alcohol is the same as marijuana. The bill does not state, in other words, the bill, the way it's currently drafted, looks like it's okay for a parent to smoke marijuana in the presence of a child. There's nothing in here that says that. This is not like marijuana, like alcohol. We know that secondhand tobacco smoke makes asthma worse, risk of respiratory disease, ear infections, and a variety of other things. I haven't seen any studies that talk about infants or children being exposed to secondhand marijuana smoke. But it is the equivalent of, when you want to talk alcohol, the way I read it, it's the equivalent of giving an underage child an opportunity to have a cocktail. I think that's wrong. And if it's somehow the bill is able to state that it explicitly forbids parents from smoking marijuana in the presence of a child, that's a different conversation. But this is really talking about not even medical marijuana. Right now, you're still breaking the law. Smoking marijuana in front of a child, I think, could be detrimental, and I'd like to hear your response to my comments.
You could probably draw his attention to page 2, lines 17 through 18.
I don't have the bill in front of me.
Page 2.
But the bill specifically says that there has to be a nexus between the marijuana use and harm to a child.
How do you know it's not?
I'm gonna.
So if tobacco definitely is.
Right.
We know that. How do you know it's not? I haven't seen
I'm
studies.
actually saying I agree with you on
Okay.
that piece.
Okay.
That if a parent is smoking in front of their child, literally in front of their child, and that child's asthma is aggravated as a result of that, this bill does not prohibit a finding of neglect against a parent who causes harm to their child because of the marijuana use. What it does is it says the simple act of using marijuana, whether they use it through edibles, whether they use it after a child goes to sleep and they smoke outside, that the simple act of using is not is not dispositive of harm to a child. It says there has to be a nexus between the use and the harm. What you described, sir, is absolutely harm to a child, or could be harm to a child, I would assume. And based on the studies you've suggested, absolutely. As a minors counsel, I have argued that it is inappropriate to smoke in front of a child all the time. But the simple act of using is not reason to either remove a child or fail to return a child. And Ms. B's situation is.
And I agree with that, absolutely, with what you're saying. The fact that I use it as a parent, I agree.
Right.
I'm talking about the specific instance where we can clearly delineate that I cannot use it in the presence of a minor.
So if you just go, so what you're saying is line 17 through 18, and that's the child's health or welfare is harmed or placed at a substantial risk. So that's exactly what you just said, and it's in the bill. So I think.
It's different because you might not explicitly see the harm done right then and there on the spot. So how can it be proven unless it's proven over time? I'm saying it sets a bad standard for a parent to be smoking marijuana in the presence of a child while it's harmful or not. I have an issue with that. Now, if it's not in the presence of a child, I agree. There's no reason why a child should be extracted from a parent. Agree. But in that case, I have a problem with that part of the bill. Thanks.
Mr. Chairman, I have a question for the second witness, please. Oh, third witness.
Ms. Stahl?
No, yes,
The
Senator, the lady, the young lady
Next
is
to me.
sitting right beside you.
Yes, okay.
Yes.
Yeah. Okay, now that we got that straight, when I read the bill, and especially that, page 2, 17, 18, it talks about a substantial risk of harm. And then when you were testifying, you were just testified as a risk of harm. And I don't know the difference. What is the difference between a substantial risk of harm and just a risk of harm? Because following up on what my colleague just talked about, and we were talking about, well, child's gone to bed, right? And now it's okay to smoke, right? You're the only parent home. It's not okay to drink, right? What if that child wakes up? What if something happens, right? It's clearly not okay, right? I don't think it's okay to, at that point in time, use marijuana that till right now is still illegal, right? And to me, as a father, I think that's a substantial risk, right? If you're the only parent home and you do that. But I don't know, I would like to know what the definition is of that.
So I think your question brings up a number of responses. One is that ultimately, one response is that the neglect statutes in general, not just in Maryland, but across the country, are written in similar, somewhat vague terms. And it's left up to the judges to determine what qualifies as a substantial risk of harm. And that question is elucidated in case law and will be left to the judge to decide. But I would bring the committee's attention back to the backdrop of all of this, which is that pursuant to the United States Constitution and, general human rights law, and Maryland statute as well, there is a fundamental right to parent children. There is a fundamental right for children to be parented by their own parents. There's a fundamental right to family integrity. And each of these statutes is built on top of that foundation. We don't sit in people's living rooms and watch what they do in front of their children day in and day out, because we believe that parents generally have their children's best interests at heart, and that this is in Maryland's law already, that parents are best situated to make decisions about what is best for their children and are most likely to make good decisions and keep their children safe. Of course, the neglect statutes have been written so that the state is imbued with power to intervene when there is evidence that parents have not complied with that duty, have failed to provide proper care and attention to their children, and have not carried their end of the bargain and are, in the Supreme Court's words, unfit. All this statute does is name and explicitly state that marijuana use, which I understand may not be exactly analogous to drinking, depending on your perspective, to alcohol, but the use of a substance like marijuana, which we do not have evidence that it is affirmatively harmful to children, that mere use, which would be evidenced in a case by an admission from a parent that they may have used marijuana in the past, or by evidence of a positive toxicology, that the mere fact that a parent has used marijuana without evidence of connection to harm to the child is not itself sufficient for a finding of neglect. And as my co-panelist stated, that shouldn't be controversial. It already is the law. We have a fundamental right to our families, and we don't go policing people's private behavior until we have evidence that a parent has failed to carry their duty. And that's all that this bill does.
So that's, I'm in agreement with you on parenting. Totally understand that. But if that child, if the parent is making a parenting decision for the right of that child, I think that it is very clear that that parent, in order to make that decision, must have a clear head. Can't be intoxicated or under the influence, right? Can't be, right? That's you can't make a parenting decision if you are not capable of making good decisions. And so that was my point. After somebody goes to bed, if all of a sudden you're going to get high, right, and then hopefully everything is good, you go to sleep and you wake up next morning, right, everything's good, that's great. You wake up next morning, child's not there, something happened, that's a significant problem.
And in that case, there would be clear evidence of substantial risk, right, and we'd be in a certain situation. But that's all the bill does. It aligns marijuana with, it explicitly aligns marijuana with what the law already says, to be honest.
Thank you.
You all have done a fantastic job. Thank you, Senator Carter, for bringing the bill. It's drafted. It's no problems, no drafting errors. It's very good policy. I'm surprised that we still do this. So look forward to working on this bill early next week to move it out of committee. We will work on, some of the members understand the exact construction of your statute here. So thank you very much.
Thank you.
Yep.
Thank you, Senator.
Thank you. All right. Do we have Robert Stencil? Natasha Kalafani. Oh, you already tossed aside, sorry, there you go. Debbie Jansen. Is Debbie still here? All right, you're up.
Good afternoon. I'm Robert Sunzel, a student attorney representing the University of Maryland Law School's Public Health Law Clinic in support of Senate Bill 772. Senate Bill 772 protects the parental rights of responsible cannabis users and the integrity of their family unit. Maryland is moving away from harmful and punitive policies surrounding cannabis, and SB 772 continues to refine this policy direction by recognizing that cannabis use that does not endanger a child's physical or mental health should not qualify as neglect of a child. The bill acknowledges that separating a child from their parents is a more significant threat to public health than a parent's responsible cannabis use. And the bill supports the effectiveness of the state's medical cannabis program, making it so that cannabis patients who are parents are not forced to choose between pursuing state-sanctioned medication and the risk of losing their children. Family separation is rarely warranted as the consequences are grave and lasting. Family separation is a well-documented adverse childhood experience, precipitating trauma, anxiety, stress disorders, and all the health complications that follow over a lifetime. Major medical associations oppose policies that involve family separation based on a body of literature that's, quote, replete with evidence of the irreparable harm and trauma to children. Separation also precipitates similar negative health outcomes in parents and violates the fundamental legal and ethical rights of parents to participate in all the decisions regarding their child's well-being and best interests. SB 772 also continues Maryland's cannabis policy direction by supporting the effectiveness of the cannabis program, as cannabis patients should not be treated any differently than any other patient who uses similarly legal and legitimate medication. Without SB 772, the threat of family separation undermines the state's cannabis policy objectives of allowing licensed providers to recommend and patients to use medical cannabis. Passage of SB 772 would place Maryland among the increasing number of states which protect the sanctity of the family and public health by excluding the consideration of non-endangering cannabis by a parent in cases of children in need. Thank you.
Thank you so much for your testimony. Questions for this witness? Seeing no questions, that concludes the hearing for Senate Bill 772. We'll now be moving on to Senate Bill 889. Mr. Laurie.
Hi. Senator Lee hopefully will be back for the short voting session, but my name is Michael Laurie for the record. I'm Senator Lee's Chief of Staff, and I'm here also as someone who participated in the Best Interest Attorney Training Program. They had great trainers. They do this training, I think, at least once a year. It's a good 6-hour program, but I found it interesting in the context of Senator Lee's work with the work group when there's an allegation of abuse during a child custody proceeding, that the linchpin, to have the difference between a best interest attorney, which substitutes their perceived best interest for the child instead of the child's preference, they do relay that on the record, but to get a child advocate, you need to overcome a threshold of considered judgment. And we've talked about children's judgment in the criminal context, and we've talked about it in the context of the rules of evidence. I think this is a very important context as well that, to be frank, is neglected. And I just want to, if nothing else, Senator Lee wanted to shine a light on this issue. There were some drafting errors, which I think resolved most of the opposition, because the real intent of this bill was to apply this policy on top of the existing guidelines when a best interest attorney is already appointed. So at that point in time, the question is, under the guidelines, has the child reached considered judgment? Should a child advocate be appointed instead of a best interest attorney, because there are considerations such as child abuse allegations in the case? And if you look around the state, and one of the amendments which we will circulate to you, we got it just after the deadline to get it in the record, but I've shared it with some of the opposition, and I think it's at least receptive to most of their opposition. I think there is some resistance to have this legislated, but it's already in their guidelines, and the intent here is really to just make sure that that process of considered judgment goes through. You can see in the written testimony there's a lot of international law in this space, the Convention on the Right of Children. I studied international law in law school, so this is kind of fun to get back to this. But the United States is the only country in the world that has not ratified that treaty. Somalia ratified it about 10 or so years ago, and even South Sudan, which hasn't been a country for more than 10 years, has ratified it. The United States partially probably because of this issue and some concerns and some paternalism, to be frank, is reluctant to relinquish control so that children have access to the court, so that their voices can be heard in the court. And a child custody proceeding, while the child has the ultimate effect at their feet, is not technically a party to the case. So even if you are appointed a child advocate, and again, getting those numbers would be enlightening, it's not clear that you could even file motions. You wouldn't have certain access to the court. One note is 16-year-olds in Maryland can motion a court in a child custody proceeding, but it's not clear how often that happens because you'd have to retain a lawyer. And at 16 in Maryland, you can't even necessarily sign a contract. We've discussed this in the absence of an emancipation statute in the state. So I think these children are put in a position where they're very vulnerable to having their considered judgment ignored. And I think in a lot of aspects, it's done as a conscious policy because the judges and the best interest attorneys feel that subjecting them to any kind of testimony, even if it's in camera, would be some kind of adverse childhood experience. And we've looked through the literature. I haven't seen that adding to the ACEs score. There was a little joke in the written testimony, maybe testifying in front of JPR adds to your ACE score. But I think an in-camera interview with a judge and explaining why the child has a preference for a certain parent, because maybe the other parent is an alcoholic, maybe the parent has some issues. For a 13 and 14-year-old, the presumption that they have considered judgment is in line with the international consensus. And all this bill does is at the point in time where a BIA, as amended, is appointed, the analysis they're already supposed to do under the guidelines occurs with that presumption, which could be overcome with any evidence, because they are still the ultimate determinator of whether they have considered judgment or not. They can state whatever reason overcomes that presumption to rebut it. And I don't think that's necessarily a harmful policy in any way, and the presentation of a child who wants to participate in this proceeding not only is in line with the consensus we have at the international level, Article 12 of the Convention on the Rights of Children, and a body of work that's followed. It's something that the children themselves want. We have an intern that goes to Walt Whitman High School. We had her survey 132 of her classmates. Most of them were 18-year-olds. 70% of them thought that the threshold of 13 and above was the appropriate threshold. And I don't think we're surveying the children who are involved in these BIA processes to find out how they felt their voice was heard in court. So short of passing this bill, I think there's a lot of transparency that might benefit this policy-making process. I think the judiciary can implement some of these things on their own. But I think this bill, as amended, is an important conversation for the General Assembly to have. So Senator Lee will hopefully be back later. I'm sure she can address any of your questions, but I'm happy to address them now. I know a lot of our witnesses had to leave early, and this is a somewhat complicated issue. I know the opposition still is opposed to the concept for a variety of reasons which they will get into, but if you look at the testimony and look at the links to the guidelines, you'll see that this is a process they're already supposed to do, and we're not taking any discretion away from the people that are already supposed to do this. So thank you.
Thank you, Mr. Laurie. Are your witnesses Mr. Ross and Ms. Rice here?
Unfortunately, they had to leave.
Understood. Questions for Mr. Laurie? All right, seeing no questions, we'll move to the opponents. Alice Mutter, Lori Ruth, Dorothy Lenig, Lindsay Parvis. Whomever would like to go first.
Good afternoon, Chairperson, Vice Chairperson, and members of the committee. My name is Alice Mutter. I am the Senior Attorney for Family Law with Maryland Legal Aid. And at Maryland Legal Aid, we are a nonprofit law firm, and we provide representation in a variety of civil cases, including representation in family law matters that include custody and access. And we also represent child victims of abuse and child in need of assistance proceedings. I will note that I have had a chance to review the amendments. The initial version of Senate Bill 889, I would direct everyone to my written testimony. We, at Maryland Legal Aid, are very much in support of considered judgment of minor children. The family law process and custody proceedings inevitably have an effect on children, and the children's perspectives
as they are currently under Maryland law, are a factor that the court must consider in making a best interest determination. And the concern was the financial implication on low-income litigants, where essentially, if a child has considered judgment, the appointment of a best interest attorney or child counsel is mandated. My understanding as to the revisions is that this would address it where it would only be in cases where child counsel is already appointed, and legal aid is supportive of having children's judgment considered by the best interest attorney, and is primarily mindful of the financial implications of mandating the appointment of child counsel where there is not already existing child counsel. While there are some limited resources to provide funding for low-income litigants to fund child counsel, that is not guaranteed, and so for that reason, while we are in opposition to the original proposal, and I understand that you all have not received the amendments, I do believe the amendments would address many of our concerns. Thank you.
Lindsay Parvis again on behalf of the Family and Juvenile Law Section of the Maryland State Bar. We are opposed to Senate Bill 889. And what I'm going to invite this committee to consider is that Senate Bill 889, in its original version and as amended, calls upon this committee to make a public policy decision, and I'm focusing on one particular area, of whether or not siblings who are appointed child advocate attorneys should be litigating against each other in their parents' contested custody case, because that's really what this boils down to. Now, there are a host of other issues in this, but please understand that the concept behind this bill is that if a child has considered judgment, that child shall be appointed a child advocate attorney. Under our guidelines, a child advocate attorney has undivided loyalty to their child client the same way they would have to an adult client. Now imagine for a moment a family that has a 13, 15, and 17-year-old child, right? All of whom may be determined to have considered judgment, but one can easily imagine that children of those different ages would want different outcomes, want to see different things happen, and that therefore they should have different attorneys. This is a tremendous burden on the children themselves, and the child advocate attorney role and receiving child advocate representation opens up that child to a level of participation in a case that is more extensive, I would submit to this committee, than as a best interest attorney. Despite the amendments, there are still issues with this case, and if I may just finish my thought, please. The amendments even call for that the child shall be appointed a child advocate attorney if they're determined to have considered judgment. I mean, if we accept for a moment that a child has considered judgment, shouldn't they also have a say in whether or not they are represented by a best interest attorney or a child advocate attorney? Instead, this is taking away their autonomy and forcing them into a process that, in having considered judgment, they might not choose to participate at the extent that this legislation would force upon them. Thank you.
Good afternoon, Mr. Chairman, members of the committee. My name is Dorothy Lenig. I'm the director of the Domestic Violence Legal Clinic at the House of Ruth. I'm going to make every effort not to repeat what folks have said. I'm not as quick as they are. I had trouble figuring out exactly what the amendment meant, but I want to make 2 points. One, if the state is going to appoint counsel in family law cases, my preference, the House of Ruth's preference, would be that they appoint them to the parents and not the children. I think that's the most important thing. Second of all, I know Mr. Laurie says that this is really the way people are going, having kids have say in family law cases, but I presented all of this to a psychologist I know. I said, what would you do in this situation? And this is what he said to me. Are you telling me the parents can't figure out the custody arrangement and the judge can't figure out the custody arrangement, so you're going to ask the children to determine the custody arrangement? That's crazy. And frankly, I agree. I forgot to say at the beginning, I'm also here on behalf of the Women's Law Center and the Maryland Network Against Domestic Violence. Thank you. Urgent unfavorable.
You all do far more domestic, and I don't even do it anymore at all, but, I mean, my experience from years ago was that in most cases, the kids didn't want to get involved in the divorce. They would rather let the parents do this, and that in some cases, and then frequently when they're 13 years old, the judge would bring them in and talk. In some cases, it was so acrimonious, in a small percentage of cases, it was so acrimonious that the judge would in fact appoint an attorney to represent the kids. But of course, that brought the challenge that lawyer's not working for free. So now we have a divorce which are typically centered around lack of funds, right? That's sort of what the kicker of the divorce anyway. So you're somewhat hesitant to do that. But of course, if it involves a really horrible divorce and you just can't get to the truth, then maybe you would bring a lawyer in to represent the child or the children to try to at least get their views. Are my experiences consistent with yours, or am I out of touch?
Exactly, and we represent all low-income people, so I'll let Ms. Parvis speak to the people who have more money than our clients. But for our clients, if the state's going to come in and provide representation, let's provide representation to the parents.
To the parents, get this
and
thing
let
worked out.
them battle it out. Yes, we definitely have cases here and there where there's an attorney appointed for the children, but it is not as a routine matter. I think as a routine matter, we want to keep them out of it as much as possible.
Right, keep it moving.
But I would
All right.
defer to Ms. Parvis.
That's right. A significant part of my practice is representing children, or it feels significant to me. It's substantial. And I have had the occasion to serve as a child advocate attorney. The majority of my work is as best interest attorney, or on occasion as privilege attorney. In any event, yes, resources are absolutely a concern, and I would say that the majority of the cases do not have child counsel appointed because resources are a concern, either because the parents are having to fund the child counsel representation, and so having to choose whether child counsel representation is the right path or other, let's say, expert services. And child counsel attorneys serve as, and I should address this to everyone, I'm just trying to speak to your question, Senator, but they serve as attorneys. They do not testify in the cases. They are not witnesses. So then parents have to weigh, oftentimes, if they are going to put dollars into services, do they want someone who's an advocate role, or do they want someone who's an expert witness? Right? So that's one consideration. And then, of course, if there are not the resources, then oftentimes, let's say, for example, courts have court custody evaluations that may be available at either no cost or very limited cost, which when compared to the cost of paying an attorney out of pocket may be a far more affordable option. So it's a fairly small number of child custody cases to which this would apply.
Right, so it's the automatic provision of this that you're trouble with, not the advocacy piece, but the automatic provision that puts us in every case, many of which the children would never be brought up. Anyway.
The automatic, because there are absolutely children who, well, are children aware that their parents have conflict? Yes. They're aware of that. There are absolutely children who do not want to partake or be any more involved in that conflict. And in my experience representing children, which I've been doing since 2007, I have some child clients who find themselves having a child counsel attorney, and they don't want to take sides. They don't want to get further into it. These are complex cases, and not every child seeks a voice not every child seeks to participate in their parents' litigation, either by speaking with the judge in chambers, as I believe you referred to, or magistrate in chambers, or by being a more active participant. Most kids want to live their lives as normally as possible, doing what kids do, not having a part of their life being dedicated to their parents' contested custody litigation.
Thanks. Good to see you again. Thank you.
Thank you.
All right, seeing no further questions from the committee, thank you all very much.
Thank you.
And with that, I believe that concludes the hearing for Senate Bill 889. We'll now move on to Senator Sidnor. Are you good to go? All right, excellent. All right, so Senator Sidnor with Senate Bill 762.
If I could have my panel.
Yes, you can have your panel come up.
Thank you. Good afternoon, Mr. Chair and committee. I'm here to testify on behalf of Senate Bill 762. For those of you who don't know, I've been attempting to address Maryland's use of facial recognition for some time now, probably dating back to 2015 when I first began looking at this issue. I had run across a publication from Georgetown Law called Perpetual Lineup, which had caused a good bit of concern. And so I've run the gamut of attempting to ban the use of facial recognition, to put a moratorium in place, all of which were unsuccessful, to where we are today with attempting to regulate the use of facial recognition technology. I will submit that I think things are a bit backwards when it comes to law enforcement and its use of technology, because what we find ourselves doing is chasing the technology that the executive branch has already put into use without the public having an opportunity to weigh in. I think that's something that we may need to look at in the future, but regardless, we're here. Facial recognition is here. After some additional attempts at trying to address this, the Maryland State Police offered me an opportunity to visit one of its fusion centers in Woodlawn, where I had an opportunity to see how this technology was used. Fast forward to last year. Last year, this committee passed Senate Bill 587 to establish a task force on facial recognition privacy protection. However, that bill did not make it out of the House. But regardless, I began conversations with everyone who was listed in that piece of legislation, and this summer, through this past winter, we met, I believe it was bi-weekly, probably had 10 to 15 different meetings where we had law enforcement engaged, we had advocates engaged, we had university professors, we had the industry, Microsoft, the Public Defender's Office, I mean, name it. I believe you could say everyone from the gamut was involved in discussions as we were attempting to figure out how to move forward with how facial recognition is being used here in Maryland. So, and with that, again, I had made clear during those conversations that facial recognition is here, so attempting to put forth any type of moratorium probably was not going to work. So we really were in a position of trying to set forth a regulatory framework that allowed law enforcement to use the technology, but would also provide certain constitutional protections and transparency and accountability by those who use it. So 762 sets those guardrails for usage of these systems by law enforcement by ensuring that it can be used as an investigative tool. We limit the types of crimes that can be investigated with it. For the greater part of the time the work group met, we worked under the assumption that the Department of Public Safety and Corrections had the only FRT system in use in Maryland. So when you look at the bill, you'll see that I'm not going to put it on them, that I said that there was going to be one type of system that was going to be used. We also provided that certain, oh, you know what, let me back up. This is what I'm going to do. I'm going to walk through the bill just cursory. So Section 502 sets forth the framework for the court to use, or how it's going to be used, and it as the investigative tool. Section 503 really kind of focuses on the types of crimes that can be used, or where facial recognition can be used. So it also notes which images can be used. And again, I want to be clear for you all that during our conversations this summer, it was my understanding that facial recognition technology, the current mirror system that we use, only uses mugshots and driver's licenses. So what I initially did when the language was crafted was limited it to what I was told our current system operates with. There was some concern that was brought forth about it being too narrowly focused, so we expanded it so that you could use other law enforcement databases outside the state of Maryland. However, I am somewhat concerned because I'm sure you all got a visit from the advocates from Clearview, which many of you may know, they have a system that essentially goes on to social media and scrapes every image that you've ever put up there, and then they package all of this stuff, and they go to companies, law enforcement, and whomever, and uses your images that you've put up on social media, and they commercialize it. I think that goes a bit far. So this legislation, as I say, it limits it, because this isn't supposed to be a general surveillance type tool. This is supposed to be an investigative tool used by law enforcement. Section 504 provides certain types of disclosures of whether or not FRT was used. So this is something that was important to the public defenders, because there have been times when there have been some suspicion that FRT may have been used, but there was no obligation on the part of the state to put that forth. 505 requires law enforcement to designate a point person for overseeing and administering FRT compliance, as well as certain audits. And we wanted to have a point person who was really steeped in how to use this. This was something that we had a professor from, I believe it was Australia, that really talked about the importance of. Section 506, again, it talks about certain requirements that we were looking for the Department of Public Safety to have with regards to setting forth policy and developing training tools, among other duties. And again, we figured they would be the best agency to do this, because they're the agency that currently runs the mirror system. 507 expressly notes 5 uses that are excluded from this statute. This is important because in some of the testimony that you'll see, or that you may have read, it really talks about how facial recognition technology has been used to help with finding people who've been missing or people who have been deceased. Again, this legislation is about limiting the use of facial recognition for an investigatory tool, so we did not want to get ahead and limit any type of use when it was coming to those uses that are mentioned under 507. 508 creates an additional duty to adopt certain data policies and certain posting requirements. 509, certainly it puts forth the ability for a person to sue in order to force compliance by the state if they are not complying. And 510 sets forth certain reporting requirements. There will be, or there have been, some amendments that will be put forth by the Office of Public Defender as well as Microsoft, and I'll have them speak to that. But the fact of the matter is this: facial recognition is here, whether you like it or not, and if nothing is passed this session, we're just going to go another year of allowing law enforcement to use it however it sees fit, and I just really believe that that's unacceptable. With that, I ask for a favorable and stand for any questions that you may have.
Good. Let's go ahead and do questions for the sponsor. If you have a question for the sponsor, because we have a big panel, so if you want to go ahead, Senator West.
Sure.
Thank you, Mr. Chair. Senator Sidner, the one thing you haven't discussed with us is why facial recognition technology is so suspect. You haven't given us a reason why we should want to limit its use. Could you give us a couple of examples of situations in which it has been misused and therefore we should want to limit its use?
You know, the thing is, I can go to, and if you look at my written testimony on page 2, I speak of how it's been misused in China, where, and I'll read, and this was noted in an LA Times article, where it says facial recognition software developed by China-based DOA, one of the world's largest manufacturers of video surveillance technology, purports to detect the race of individuals caught on camera and offers to alert police clients when it identifies members of the Turkic ethnic group, the Uyghurs. And given this state's movement towards adoption of police body cameras, we have to consider how police using them can quickly and easily amass probe photos of protesters, thus creating a chilling effect. Anyone who attends a protest may be subject to the inclusion in the perpetual FRT lineup. So that's in China. Trying to prove or disprove this is difficult. But let me go. So in the early 2000s, our Maryland State Police Department, they were called out when they were surveilling people who were engaged in their First Amendment rights. So there's nothing, again, except for us relying on the state police and their word that they're not going to use facial recognition, so that if I'm going out and protesting and engaging in my First Amendment activities and my right to do so, that I'm not being surveilled and then my face isn't being run in this perpetual lineup. So right now, and I believe it's, when you think about it, me and anyone else right here who have driver's licenses and those IDs, your face is probably already being used in that manner. So we've had cases in Chicago where facial recognition technology has been used and used and misidentified someone. That person was then arrested and later found that it was a mistake because of the use of this technology.
Well, could I interpolate a comment? We not only, we have photographs that are taken. If you're trying to surveil somebody who's engaging in First Amendment protected activity, you have photographs, you have video, you have cell phone footage, and I guess you could have facial recognition technology. Why would you single out facial recognition technology as opposed to the other ones if what you're concerned about is surveillance of people in exercising their First Amendment rights? Why would you want to focus on this narrow subset of the possible ways in which the images of that person could be captured?
Well, the thing is, this particular technology, and again, we're just talking about the beginnings of the uses of it, it can be, as mentioned in the situation in China, that it can be used and partnered with your body cameras. And so essentially now you've just turned this tool that was supposed to be used for accountability into a surveillance tool. And I don't think any of us, when we were adopting our body camera legislation, were attempting to create a surveillance state or some George Orwell 1984 type thing. So those are concerns that I have, especially when it comes to those who are worry about the infringement on one's privacy rights.
Okay, but body cameras aren't facial recognition
Body
tools.
cameras have been tied, and I'm sure some of the people on my panel can talk to some of this
Okay.
stuff much better than I can.
Okay.
But they thankfully, we've had some companies who have pushed back when law enforcement was attempting to do that, and they said, no, you're not going to use our technology in that manner. So it is a concern.
I know, obviously, this cuts both ways. It's fascinating technology, because, you're thinking about, I'm thinking about personally January 6th.
Yes.
Where this technology was used to get a lot of the folks.
Correct.
Who are now going through the criminal process. So, it cuts both ways, but I wonder, we have 180 police, departments or agencies, law enforcement agencies in the state. I think it's 180. And so then, each maybe using different tools or methods or contracting with different companies to get this information. And I wonder does it make sense to say, hey, look, if you're going to enter into this type of an agreement, that there are some best practices or standards? Does it make sense to do it that way? I see there's one witness there. Maybe you can address that. But these are some things that are kind of kicking around in my head.
No, and again, when this legislation was put together, there were certain assumptions that were made because of things that were said within our group. And my experience in engaging with this, I had believed, or I was led to believe, that we had one system, that you kind of came into that system to use that system. Later on, in conversations in the work group, when I began putting the language or the words on the paper, we began realizing that, okay, it's not just this one system that's being used in Woodlawn. There might be another police department that is using it. Delegate Moon, who was on the work group with us, began asking questions of the Montgomery County Police Department, trying to find out, well, what are you using in order to compare photos? And they were, from my conversations with them, they were extremely hesitant to reveal what they were using. So again, when you have this type of secrecy, it raises alarms. One of the things that we did, and again, I'm not necessarily opposed to kind of what you're suggesting, so long as there are going to be certain parameters put in place, some of the parameters that are right here, and some that you're going to hear about. I think Microsoft in the amendment that they're going to be speaking to. Thank you.
Got it. All right, thank you very much. Thank you. All right, excellent. Whoever wants to go up, if we could just come to the podium, please. Thank you.
Well, thank you, Mr. Chairman and members of the committee. My name is Owen Larter, representing Microsoft. I did want to say a big thank you to Senator Sidner for his really important leadership on this very important work, and we appreciate the opportunity to testify today. So there's really 3 points that I want to make. The first is that facial recognition is a new and powerful forensic tool that is already being used and for which we now urgently need new law. Secondly, we think this bill represents a real opportunity to ensure that police can continue to use facial recognition to deal with serious crimes, to identify missing children, but only in a way that is rights-respecting, transparent, and accountable. And then finally, we support the amendment that has been put forth to ensure that systems are tested before police use them, because it's really important that police are using only the most accurate and non-discriminatory technology. So Microsoft believes that facial recognition can bring benefits to society. We also recognize it can create potential risks around unfair and biased performance, around invasions to privacy, and potential threats to democratic freedoms. And so that's why we think there is a real urgency to create new law in this space. We think there is particular urgency in the law enforcement context, given the consequential nature of the decisions that police take. And so that's why we support the safeguards that are in this bill. We think the civil liberty protections are really important. The prohibition on using the technology for invasive mass surveillance, the prohibition on using the technology to profile an individual on the basis of their skin color or their gender or another protected characteristic. We think the transparency and accountability mechanisms are really important. It's important that there is auditing and reporting requirements so that we know how this technology is being used. And the requirements for human review of the technology are really important as well. We do think that a requirement for third-party testing is a really important addition to the bill. There is a significant variation in the performance of different facial recognition systems. So it's really important that we have this testing so that police are able to identify the best performing systems and demonstrate that the technology can be trusted by the public. And I just, in my final remark, note that this is the type of testing that is pretty commonplace in relation to other forensic tools like DNA analysis. We think the same should be applied to facial recognition. Thank you very much.
Thank you, Mr. Chairman. My name is Andrew Northrup, and I'm with the Public Defender's Forensics Division. And so we get cases from all over the state. And only in the last year did we start getting cases involving facial recognition. And first of all, I'd like to thank Senator Sidnor for his leadership and his tenacity on tackling the subject. And just want to say that since we've been dealing with this bill represents a very important first step to regulating this and establishing that independent evidence is needed to establish probable cause, and establishing transparency requirements. You heard Senator Sidnor say a lot. I was told we're not quite sure every way that this is being used. All I can say is the cases that get referred to the Forensics Division and the uses that I've seen, which some of them seem like they're fairly routine, some of them are frankly a little bit alarming. So we just want to make sure that the transparency part is very clearly put into the bill, and the amendments that we have offered to this bill have basically been things to clarify what the intentions of the bill are. We want to make sure that this bill falls under Maryland Rule 4263, the discovery provision, so that we do get all of the discovery anytime this is used, because even assuming that they do not identify the client, a lot of times this material can be exculpatory, and there are other things we want to look at as well, just to ensure that it's being used properly. Additionally, we want to make sure that under no circumstances is this ever considered evidence in court. Because one of the things you were asking about was best practices, and the fact is this field is in its nascency, and the fact is those practices are still being developed. And again, this is one of the issues with a lot of these law enforcement technologies, is that they get used before they've been fully validated. And that's another thing that we want to talk about as well, is one of the things we want to make sure that has to be disclosed on the website by anybody using this is their internal validations as well as the developmental validations for any of these programs that are being used, so that we can see how effective these are. And you're asking about the issues with the facial recognition. The thing is that we're not quite sure how accurate it is. It has a long way to go in terms of like the algorithms are quite, have gotten quite sophisticated over the past few years. However, the fact is that we as human beings have only been using facial recognition for the last 100 years with the advent of photography. Historically, we've identified people by their gait and other bodily features as well. So we're not really good at it, and we think we're much better at it than we are. So there are a lot of the issues with eyewitness identification exist with facial recognition. Thank you.
Good afternoon, Mr. Chairman, members of the committee. My name is Nathaniel Erb, here on behalf of the Innocence Project in support of SB 762. The work of preventing wrongful convictions is often that of hindsight. 32 people have been exonerated in Maryland so far. In response, this body has passed several reforms based on the factors that led to those wrongful convictions. This is one of the first few times that we can act proactively. While we do not have a full understanding of how often facial recognition is currently used in the state of Maryland, that prevents a problem for being able to identify how many times it's used incorrectly. We have identified the first couple number of situations in Chicago, as Senator Sidnor spoke to, as well as in New Jersey and a couple other states. But in the position of the Innocence Project, it usually takes decades before a client comes to our office and we're able to help them to prove that there's been wrongful convictions that have happened at the result of technologies like facial recognition. As a working group heard evidence of, human biases, particularly along racial lines, can be baked into the technology and the underlying source material. Even if the technology is sophisticated, the working group found there simply isn't yet adequate training to ensure accurate identification by the user themselves. There is a significant variance in the efficacy, as my colleagues from Microsoft spoke to. SB 762's regulations on databases and vendors are crucial. Budget constraints, deceptive marketing, and other forces encourage the use of less reliable systems. The technology may help us identify people in the most heinous of crimes, but the question remains, are those reliably the right people? In some of the first documented wrongful arrests related to this technology nationally, the misidentification of innocent people by facial recognition even overrode other exculpatory evidence. We see this to Senator Est's question in, we have worked on laws with this body and many other states working to reform eyewitness identification. The problem is you can't set standards statewide to address every single instance of facial recognition technology, because the technology of looking at a person with my own eyes is the same in every person. The technology of what's being run behind the scenes of the individual system isn't standardized. So we are not at a place yet where we can say these are the technological limits, necessities, and tools that have to be in place to validate your system. So we couldn't evenly apply them across every single system in the state. And I think we need to get our hands around what's actually being used. And to the senator's point, we were led to believe that there really was a centralized system, and it wasn't until we decided to talk about enshrining it and making sure law enforcement was able to continue to use the system that they led us to believe was being used, that we began hearing these problems of needing to expand beyond that. So we'd urge a favorable report.
Thank you, Mr. Chairman, members of the committee, and thank you to Senator Sidner for inviting me to testify today. My name is Katie Kinsey, and I'm an attorney with the Policing Project at the New York University School of Law. Our organization is dedicated to partnering with communities and police to promote policing practices that are transparent, ethical, and democratic. The current unregulated use of facial recognition technology by law enforcement in Maryland is a recipe for harm. There is an urgent need for the type of nuanced, comprehensive legislation that's in front of this committee today. And that's why we support this legislation, although we would suggest some amendments that we think can strengthen it even further, two of which I'd like to focus on today. The first is something that some of my co-panelists have already touched on, which is the need to know whether this technology is actually accurate as it's used, and that happens through testing. Your constituents deserve to know whether this technology is producing accurate and unbiased results in the ways that law enforcement is using it. That means with a human in the loop, that means with the types of images that law enforcement is actually using and the types of databases they're using it on. We can only know this if we test the technology. Luckily, this body is uniquely positioned to address this problem by amending the bill to require that these systems be tested for their accuracy in operation. We would suggest that this body convene a task force to develop a testing protocol that can be used either by agencies or by independent third-party testers to verify whether the technology works as it's intended to work. The second suggestion we would make in the form of an amendment is that this bill should only authorize facial recognition use for a limited period of time during which you assess its impact on public safety. Right now, there's too much that's uncertain about the use of facial recognition technology by law enforcement. This bill has really important requirements for data collection and reporting. If you combine that with operational testing data, you'll begin to get a sense of whether this technology is actually making Marylanders safer or whether it's causing more harm than good. Thank you.
Thank you very much. And thank you, Senator Sidner, for the bill. I did have an opportunity to speak to the senator about some of my questions, some of my concerns. So let me say off the bat, I don't have a problem with law enforcement using any law enforcement database to catch bad guys. I don't have a problem with the federal government reaching out to an entity to help capture those who were involved in January 6th. The thing that troubled me is that you have individual companies who are scouring the internet, creating their own databases full of photos, and then selling it to a third party. Now, there's this back and forth conversation that if it's on the web, it's open use, it's public, can have access to it at any time. But, and I have the attorneys in the room, I don't think it's fair to say that you can use my photo in a commercial enterprise. And so my understanding is that we have companies who are leasing their technology to law enforcement. They're still making a profit. And the question for me substantially is that, is there a reasonable expectation of my privacy, even though I post something on my personal Facebook page, and can you just arbitrarily use it for a commercial purpose? That's number one. Let me just get a couple of these things out. I'm glad you said you're not talking about any of this being used as evidence in court. So that takes care of my deep fake issue. I did have an opportunity to read the end-user license agreement for Facebook and all the instances that they use your information. And what I discovered is that there are very specific informations they use your information, share with third parties, mostly to optimize their system. but when it comes to law enforcement, it's always at the request of law enforcement with a warrant. And so my question is, currently right now, if law enforcement wants to search for an individual, is there anything required from the court? Is a search warrant required?
No, Senator.
It is not.
Not under the current state, and we didn't, we had contemplated this in the committee, and I think the senator can speak to.
Yeah.
I think from our panel's perspective was a balancing act of what are the limitations we're putting on it and what would potentially go far. Our office stands from a moratorium perspective. We also would support a warrants requirements to make safety, but under the current bill, and especially under the current status quo, there is no warrant requirement for the use of facial recognition.
And so you had mentioned that you were concerned about adequate training for the users. If this is your system that you own and operate, would you be the sole users of it, or would you be leasing the technology and allowing law enforcement to use it as they see fit? Or is it a case-by-case basis? They're looking for a specific individual, and they have whatever we deem as appropriate permission to go ahead and use it for that instance.
I believe originally as contemplated by the senator in the bill was that, as it was told to us, the Maryland State Police operated their own system, and through the Fusion Center, various agencies across the state, wherever they may be from, can make requests of the Fusion Center to run facial recognition searches on their behalf.
But that's with their current databases,
That would
right?
be with the current database.
So I'm only I don't have a problem with any of that. And I agree with you, this is the way technology is going, and we just got to wrap our arms around it. My issue is this third party that scours the internet, creates their own database, and from what I was briefed, about 10 billion photos. When law enforcement fails to get a hit, that's submitted to this third party, and they do these searches. Or they license the technology back to law enforcement, and they do the searches.
For
right?
all those reasons is why we also strongly stand in favor of limiting the use of facial recognition technology to state databases.
Right.
So you can obviously still use any photo you collect from any crime scene in any circumstance of the crime that's covered by the bill. The actual database you're running against would be limited to those state and federal databases. From our concern, not just simply, I think there is a public privacy concern, as you're stating. From the Innocence Project perspective, we found that eyewitness identifications is the leading false identifications is the leading cause of wrongful convictions through DNA. That's been proven. And so not only is base use of photos where you have a clean, clear photo from a lineup which you're comparing against, but now you're talking about Facebook photos that have been altered, not a direct angle, all these various different variations of photos scraped off the internet that are not a clear comparison that you're pulling against. So we have even more concerns in line with you.
So, go ahead.
Should I get up, or I can sit here?
You're good there.
Yeah, please stand.
Okay. Excellent. I think it's a really important set of questions, which firstly points to the fact that we really have very little understanding about how this technology is being used. There is a real lack of transparency and a lack of certainty around how this very powerful technology is being used, which is why we think we need these basic guardrails. On the database point in particular, I think it's really important, the provisions that the bill have to make sure that police can only use facial recognition to search high-quality images in those government databases. Firstly, for the reasons that you mentioned, I don't think it seems right that you have an organization that is scraping private images of social media without the knowledge or consent of a user, and then using that to run facial recognition searches against. The second piece, which is perhaps as important, if not more so, is an image quality issue. So facial recognition is much more accurate, is very accurate on high quality images. That accuracy goes way, way down when you have lower image quality. And so the high quality images that you have in a government database, like a mugshot or a driver's license where someone's looking straight on, you get good results on that. But on social media, when it could be photos of anyone in a club with a hat on or dark, you get.
I understand the resolution piece. So the example I was shown really was fascinating. They were looking for a specific individual. It was introduced to this database, and I think, if I'm not mistaken, they found the individual in Bangladesh, child sexual abuse, and they were able to get this person. But here's the other part of the scenario. You and I are in a place that maybe we don't want the general public to know we're at. Somebody inadvertently snaps a selfie of us, and they're looking for another individual who actually happened to be captured in the photo. They go through their algorithms, they find you, they come knock on your door and ask you where you were to try to get back at this person. You know, that's the one thing, your privacy, in that instance. The other piece is the fear that instead of just searching for a specific individual, it could be used for surveillance purposes, that I want to track where this person is. And I want to make sure, and I'm sure, the senator probably has that baked in here. I haven't read it because your report was pretty thick when he handed it to me. And these are the concerns that I have, and I'm willing to work with the senator to try to resolve some of these things. But again, my line of questioning is really geared toward this third party that is not related to law enforcement, that is using readily available images, and they're using it for a commercial purpose, and I want that legal question answered.
So we would agree with your concern on that front, and we do think the provisions in the bill around being very clear about the databases that can be searched are really important.
Thank you. Yes. Thank you very much. I appreciate it. Thank you, Senator Sidnor.
You got me on now? Yeah. I thank Senator Sidnor for bringing this very important bill, because this is, I believe that we're dealing with new technology whose uses can be very boundless, beneficial too, but also could be used for not so good purposes too. So I was just, I think that Senator Watson brought up some good points about guidelines and guardrails, and so did you all. And I think that's very important as to how this data is used and whether or not it's accurate. So, but this bill would not stop police from using facial recognition. Is that correct? And also with the third-party testing component, that's not burdensome, right? But I don't see that. I'm not sure if that's happening right now where there's adequate testing. And that's something we need to do, perhaps, to ensure that that everything is accurate and it's being used correctly. Can you answer that question?
Absolutely. I mean, first of all, that's not, basically what it's doing is it's asking that the algorithm that is being currently used be available for third-party testing, which presumably would not be, we're not looking for the source code, we're not looking at anything, we just want to be able to test it. And I think equally what they can do is release what's called developmental validation, which is any time that any of these algorithms are developed, they do what's called developmental validation, which is just making sure that it works properly. And then there's an additional test that each lab should do called internal validation, making sure that they themselves can get the same results that the developmental validation through. And all of those things should be transparent, and that's one of the amendments we want is to put those on the internet.
And
so that
that's not
anybody
burdensome on the state, is it?
I would not think so. I mean, because we do this with other things as well, like, for example, with DNA, we ask for that.
And you do with other technology, right?
Well, other forensic sciences and other technologies, absolutely.
So it'd be something good to put in the bill, at least look into that.
Right. I mean, that's absolutely.
Thank you.
Just to echo that, I think that was our read as well, that the bill would continue to allow police to use the technology for really important purposes like addressing serious crimes and identifying missing children. A lot of the ways that it seems from testimony that police are currently using the technology, it would just put some safeguards around it. And the third-party testing piece, yes, we agree that's very important as well. And that third-party testing requirement would be on the vendor of the technology to allow for testing to make sure that it's accurate. Again, this is really important because there is a wide variation in the performance of the technology, so it's important to demonstrate that the technology that the police have actually picked is working appropriately and in a non-discriminatory manner. And again, we make that parallel back to DNA analysis, another powerful tool that is used by law enforcement and undergoes extensive testing before it is used.
Great. Thank you, and thank you for your testimony.
So why should a third-party vendor allow us to test their proprietary information? Why should they disclose their, I mean, as I understand it, the people who do really good with this stuff, they're not going to tell you how they do it. And if you're going to say, well, show us how you do it, they're like, we won't do business with you. And then we will be without the best available information. I'm just missing the whole point. I'll be really frank. I'm missing the whole point of this bill, because if we were using this as like DNA, where we actually take DNA and say, I studied the DNA, it's you, right? The expert comes in and says, Frank, you did it, here's your DNA. But my understanding is we're not doing that with the pictures. We're saying, third-party vendor, here's a picture. Can you find anybody that this looks like? We find these two people. Now, they're not guilty. There's no DNA analysis. You can't bring that into court. That's not evidence. It just tells the cops, okay, here's a guy that might fit. Go find him. find out where he was. If he was in Asia and the murder was in Annapolis for the last 3 months, well, you discount that guy. But if he happened to have been around the corner at the time of the murder, then you take it a little bit more seriously. So I'm missing the whole point here, to be quite frank, because it seems to me that if we were using this as a photo array, for example, but we're not. If you want to use it, then you have your points are all valid. But my understanding is the majority use for this thing is just find us this guy. Find us someone that looks like this picture, give us a tip, and we find him. Now it's up to you, police officer. We gave you a name, and that's it. Now you go figure it out. Maybe it's the wrong guy. What am I missing?
Well, actually, one of the things that this bill does is it allows it to be used as an investigative lead, and they have to develop independent corroborating evidence.
Of course you do. Of course you do. Is anybody suggesting that we're going to use these photos like DNA evidence? Or we're going to say, this technology picked out Fred Smith. He must be guilty. Jury, we put this in the machine, and the machine said Fred did it. It's Fred. Nobody, is anybody proposing that?
Well, Senator, we actually had a case where somebody was charged based solely upon a facial recognition hit. They never even went and talked to this person, and this person was charged based solely upon...
Okay, but we can't make up for stupid with the law. I mean, if you have an incompetent judge, we just can't...
Well, that's what's charged. Fortunately, the case actually wound up going away, but this is actually one of the things that we want to codify and put that into law so that can't happen.
But it sounds like we also want to deprive Maryland of the use of the best vendors, because the best vendors were this little teeny state in this great big globe, and if we say, okay, to do business here, all you do is disclose all your proprietary information, they're going to say, okay, scratch Maryland, next.
That's not what we're doing at all. I mean, because what you're saying is asking for source code, which is something different. We're basically asking to test the software, which is basically getting the project, and it's sort of like basically like taking a test drive on a car rather than being told all the secrets about how to get out, like how it's all engineered. That's not what we're after. We're basically only after just being able to test it.
Yeah, I'm going to say no. You're a little teeny state in a great big country. Okay, thank you.
Okay.
So just to add, we do think that this technology, if it is going to be used as part of an investigative process by police to take a decision to potentially arrest or detain someone, it's really important that it's accurate and it's not performing in a discriminatory manner. And we do think the third-party testing is really important because of that. The amendment, to your point, the amendment doesn't require any divulging of proprietary secrets or source code. I mean, I work for Microsoft. We make facial recognition systems. We would not be advocating for a testing system that would mean that we would have to give up our proprietary information.
But police
there are ways to do
investigations-
this. There are ways to do this testing.
Sure, but police investigations every day turn up people who, maybe it's, we get the photos, we find 15 people who this sort of looks like. And that's all this does. It gives you now you get 16 and 17 people that it looks like. And now it's up to, none of those people are now, if you charge based upon the photos said it looked like them, well, that's, police malpractice. I mean, there's got to be more to that. You then take each of those photos and start saying, not this guy, not this guy, not this guy. Hey, wait, this guy, he was there. We should look more closely at him. I mean, I'm just missing, why would we, we're in a world right now where 100 years ago, whoever perpetrated the crime, we knew couldn't be more than a mile or two within the first 20 minutes. And within hours, he could still only be maybe 30 or 40 miles from the crime. But now within 2 hours, you can be thousands or hundreds of thousands of miles away from the scene of the crime like that. In 5 minutes, you can be 50 miles away. So if we're not going to take advantage of the technology, then we're sort of depriving ourselves. We're making our state more unsafe than it needs to be. And it seems to me that's what we're doing here. We're saying let's sort of conduct law enforcement with both hands tied behind our back and not take use of the most available technology to try to keep up with the criminals who are oftentimes really vicious, who are international, multinational, who have false IDs, who can come and go so quickly, and we're just this little teeny state sitting with 95 and 40 and 50 running right through the middle of our state and all these other major highways. So people can just fly through here. And all we want is a little bit of technology so we can try to keep our communities safe. It seems like this is a backwards move, but so we'll take a look at it. Thanks a lot.
We would agree with you that the technology should be allowed to be used by police for the investigative purposes that you mentioned there. The problem is there are no rules that stipulate that at the moment, so the technology could be used for anything. So we think the bill, in setting out that the technology can be used for investigative purposes only, would be a helpful step to sort of formalize what we've just discussed here.
Thank you, and if Mr. Lauder could come back up, because I agree 100% with Senator Castley that we want to make certain that we have the best technology available. The question is whether or not we have that best technology available. So, I mean, it's my understanding that Microsoft currently has a policy where you all aren't allowing certain places to have your technology. Is that correct?
Yeah, I mean, we think facial recognition is a very powerful tool, and so we're being very careful about how we use it. We currently have a policy in the US that we're not selling to police in the US until there is a facial recognition policy grounded in human rights to provide those protections.
And would you say that your company probably has some of the best technology around?
We like to think so. We also think other people can see that because we allow for testing of our systems to prove that it's accurate against others.
Could you say that again? You allow for testing?
We do. We are enthusiastic about testing because we think transparency in this space is really important, and we are willing to open ourselves up to transparency in the testing of our systems.
Because I know in looking at, and there's a testimony in our file from one of your the industry people, and I didn't get into it, but there's really been a lot of discussion regarding bias and these things not being able to identify people of color as well as they can identify white people, right? But it's my understanding in speaking with you that those type of errors can be reduced tremendously based on having the best technology available, correct?
That's right. The technology has made huge leaps in the last few years in terms of accuracy. So the best performing systems are highly accurate, including across different demographic groups. The problem is there is a real variation in the performance of different facial recognition systems, and the less accurate ones also tend to be less accurate across different demographic groups and potentially more biased as well. So that's why the testing is really, really important, so that police know that they're using technology that is effective, and also so that everyone in the public can see that this is technology that we can trust to perform accurately and in a non-biased way.
Because it does not help just to arrest someone. You want to be arresting the right people, right?
I would think so.
So you don't want just any mom and pop shop that might have some technology and call it facial recognition in the state going out and buying the cheapest mom and pop system on the block just because it's the cheapest system. You want something that is accurate and is going to catch the people and develop the best leads, right?
Exactly. Allow for the technology to be used for ways that can benefit society, but with guardrails around it, and make sure it's only the most effective, accurate, non-discriminatory technology that's being used.
Thank you. If I might ask Mr. Northrup a question.
Senator.
And thank you. If this bill was enacted into law, and let's say we had a January 6th moment here at our state capitol, would this bill prohibit law enforcement from using facial recognition?
I don't think it would, no.
So it's really, that's enough. Thank you.
I think that if you're going to use this kind of technology, you want to use the best one, and you want the one that's going to achieve its purpose, which is to accurately identify the individual and not have any mistakes. As I know there's some evidence that facial recognition, some vendors perhaps misidentified people of color and women. And technology may not always be perfect, but you do, as I think Senator Signor said, you just don't want to get some, you know, the lowest cost type facial recognition. You want to make sure you test it and you get the best, and these are just creating guardrails, right, and kind of standards.
If I can respond, Senator, I completely agree. The reason our office still has a moratorium stance on facial recognition, though we're here in support of the bill, is because we've seen through one of the leading causes of wrongful conviction is the of overbelief in our ability to recognize faces. And so if we can't even recognize the person across from us properly and identify them, and we see that the over-reliance on misidentifications by eyewitness leads to a hyper-focus on that suspect and an ignoring of other leads, as well as ignoring of exculpatory evidence, which we see throughout cases of wrongful conviction, our concern is through a technology that is designed to give you a result and no way to independently validate if that result is reliably correct. You will have an even greater reliance on that system and a trust in that system than you would a stranger. Because if the system is something that you've spent hundreds of thousands of dollars on, you're going to have a bias to believe in the system and want to make sure that that's validated in some way, and it will lead to you going down the rabbit hole of identifying the wrong person, ignoring other leads. Another biggest concern is wrongful convictions that are extreme public safety concern. Of the first 375 wrongful convictions in the country, we were able to identify the actual perpetrator in 50% of those crimes. Of those 100 or so perpetrators, they went on to commit an additional 186 violent felonies while someone else took their place. So those are not violent offenders who are roaming free while someone's looking for them. It's even in a worse situation where you have a misidentification, you now have a violent offender, and no one's even looking for them anymore.
All right, excellent. Thank you all very much. We'll have to switch on to the next panel. All right, we have Brian Carney and Jacob Parker.
Good evening, Mr. Chairman and committee members. I'm Lieutenant Brian Carney here on behalf of the Maryland Chiefs and Police and Sheriff's Association. Currently, I'm an Anne Arundel County Police CID commander with 20 years law enforcement experience. We oppose Senate Bill 762. Here are some reasons why. Unfortunately, this bill takes away current law enforcement investigative tools. Establishment of a single facial recognition technology restricts access to tools essential to human trafficking and child sexual exploitation investigations. It also prevents use to help ID crime victims, witnesses, or persons of interest with no criminal history or state ID. Bill limitations could also adversely affect our ability to rapidly produce leads, and it makes it challenging to investigate cases where the only images are publicly posted open source information. We have seen this in some mass shooting attacks, school shootings, and the U.S. Capitol unrest. Maryland law enforcement has successfully used facial recognition for years, and we have provided some examples of this with our written testimony. We support reasonable safeguards which maintain privacy and civil liberties. We also support proper use and appropriate agency policy standards. We don't support removing tools which quickly generate leads, fight human trafficking, solve crimes, and make our communities safer. For the last 6 months, we worked with the bill sponsor and the other stakeholders to craft acceptable legislation, and more work needs to be done. We're happy to continue working with the bill sponsor to remove harmful limitations, and we have provided him with amendments which address our concerns. It's only March, and Maryland has seen 116 homicides and 232 non-fatal shootings. In good faith, we can't support parts of this legislation which limit our ability to keep Marylanders safe. Therefore, we urge an unfavorable report.
Hi, good evening. Jake Parker here with the Security Industry Association in Montgomery County. We're a trade association of security and life safety companies, and our members include the leading providers of facial recognition in the U.S. We support rules that ensure this technology is being used by law enforcement in ways that are lawful, effective, accurate, and non-discriminatory. For many years, Maryland communities have benefited from the effective law enforcement use of these technologies without a single instance of misidentification or misuse, and every indication it is being used in a bounded way. And I really encourage you to take a look at some of the nearly 20 example success stories that the Chiefs Association has provided. On the other hand, there's significant public concerns have been raised about how the technology might be used in the absence of uniform rules. It's been my understanding from the sponsor and being part of his work group on this issue that that's what this bill is supposed to be about. We support many of what we would consider the core elements of the bill. I think the Senator's done a good job of identifying those. For example, potential matches from the software can't be the only reason to go out and arrest someone or be used against them in court, as well as the transparency and accountability that comes from public reporting, regular audits, and standards for agency policies. However, the bill includes additional and unnecessary restrictions that will eliminate current proven tools for keeping our communities safe. For example, a single platform or data source limits the ability to identify someone who doesn't have a criminal record or ID in Maryland. To analyze open source information also that investigators already have access to. And it was said earlier, this would continue to allow to help children, use the technology to help children, but there's a total prohibition on using images of minors in the bill that's going to hamper investigations of child sexual exploitation. As a Marylander, I want law enforcement to have all the tools that they need to keep our communities safe, especially when shootings are up 40% in the last year. Also, we really believe that increasing the accuracy and speed of investigative work that this technology provides will reduce unnecessary contact with police in our communities and be a check on human bias and flawed eyewitness testimony. With a few changes, this could be the strongest bill in the country that allows law enforcement to continue to provide these proven benefits, as well as keeping them in check with reasonable safeguards. And we support the amendments that the law enforcement community has provided to the sponsor and to others in the committee.
Thank you, Mr. Chair. For the gentleman from the Security Industry Association, could you go back up to the podium? That way you're on camera. I have your testimony, and two portions of it jumped out at me. There's a sentence: facial recognition technology has been successfully utilized by Maryland law enforcement for over a decade without a single instance of misidentification, misuse, or false arrest. Is that the data that you have available to you?
I've seen no verified reports that has been the case.
No verified reports of misidentification, misuse, or false arrest?
Correct.
And then the second part, because there has been some question raised here about the ability of this technology to accurately identify African-American people. You have a long paragraph, which I won't read all of, but it says the evidence most cited in the media along these lines is either irrelevant, obsolete, non-scientific, or misrepresented. An analysis of NIST test data from 2021 shows that each of the top 150 algorithms are over 99% accurate across black male, black female, and white female demographics. Could you elaborate a little on these statistics?
Sure, and unfortunately, there's been a lot of misinformation in the media about the performance of the technology. It's true that some older forms of the technology, particularly 5, 6, 7 years ago, struggled across demographic groups to perform consistently. But in recent years, that issue has really been addressed with dramatic increases in performance of the technology. So today, the leading technologies that are used by law enforcement, they've been evaluated by the U.S. government, and the leading technologies do not have this issue of variable performance.
Again, I don't want to go into great detail about your statistics, but just one, it says that the accuracy rate has been tracked at 99.8%.
That's correct. The leading technologies will be able to match photos with that level of accuracy.
Thank you very much.
You'll notice that this bill, or iterations of this bill, have been around, not this bill, but regulating facial recognition technology. And remember that Baltimore, or Georgetown Law Center used to come in, their privacy center used to come in all the time with that, with regard to the racial disparities and the recognition. And that's, to your testimony, that's been largely resolved through evolution of technology. But I guess, Mr. Parker, wanted to ask you a question about the efficacy or the utility or the helpfulness of third-party validation. Can you just walk us through that?
Yeah, so that was brought up in the testimony in the panel earlier. So, and I've seen the proposed amendment that we were referencing. So it is important to have validation of this technology performance, but the problem with that amendment is that it would, to Senator Lee's question earlier, it would create a very difficult burden for companies, because typically the companies that provide this technology to law enforcement and government aren't going to make their technology available to any third party to test. And the way that amendment would operate would be, if you don't do that, you can't be a provider to agencies. So, and it's really unnecessary, because we have right down the road here in Gaithersburg, the National Institutes for Standards and Technology. They have a 20-year program for evaluating facial recognition. It's the world-leading program, recognized as the standard for objective scientific testing of accuracy. And so all of the technologies that would be utilized in law enforcement applications are part of that, are submitted to that program.
That tags on to what Senator Cassidy was talking about proprietary practices and so forth. But so just to say that one more time, through NIST, the NIST process, if you want to participate in this space, you have to go through somewhat of a clearinghouse through NIST.
Well, yeah, so you're not required to. It's a voluntary process, but it's the standard. If you are saying that you have high-performing technology in this area, you definitely participate in that program. And, there has been some, some claims earlier that there may be some problems with that program, but I'll tell you that there are tests that's done there that are relevant to law enforcement applications. There's one that's even called the Investigative Performance Test. They test images of varying quality, not just high-quality images, including from webcams and what's called wild images, across different demographics, and also on data sets that are the same size or larger than what law enforcement would typically be searching.
All right, Senator Watson, and then Senator
Just a quick question. So if you're validating the performance of your system, you don't have to disclose any proprietary information. It's effectively a black box. You get a sample set of data. That same sample set of data can be used on multiple systems, and you're looking for a correct hit rate, right?
I don't think that's the way that that amendment reads. So that's
No,
the input from
not the amendment.
Yeah. Oh.
In practice, when you're, even if you're beta testing a system, I mean, in practice, in the analogy I like to use is a home router. I get on a little app, I want to test the speed. I don't know the guts of that router, but this can verify how fast that router is versus this router versus that router. So it seems like if a cognizant body put together enough test samples, know what 100% looks like, and provide that to you all, and you start running these samples through your database, you come back with a hit rate. That would allow law enforcement to know which technology right now has the best performance. Is that a fair statement?
Yeah, and that's exactly what the NIST program does. So
Okay.
that's there. It's provided. It's tested in a black box format, and there's an information, agreement between the government and the submitting parties.
Got it. Thank you.
Thank you. This is for Mr. Carney. You had mentioned that this takes away a tool, and I'm curious if you would not mind expounding how it takes away a tool.
Yeah, no problem, Senator. Thank you for asking the question. So there are a varied amount of tools available to us with this technology. So what I'm specifically referring to in my testimony is a tool called Spotlight. What this does in human trafficking is this will go and search essentially through the National Center of Missing and Exploited Children's database, and it will also go ahead and search through the internet for photos of children that are either being endangered through human trafficking or just sexual exploitation. And it's used heavily by units that investigate those type of crimes.
Now, if I'm not mistaken, though, for those who are missing, this bill excludes those, so that tool wouldn't be taken away in that instance, right?
It would prevent us, unfortunately, the question is really the image repository of which being searched. So Spotlight searches open source information, and unfortunately, we're limited to the motor vehicle photos and the booking photos. So we wouldn't be able to use Spotlight to search, open source information to accomplish, investigating those cases, unfortunately.
But again, if you're allowed to use this tool to deal with missing children, how is this bill prohibiting you all from using that tool?
So I hear what you're saying. So let me just kind of make sure I understand. So I'll give you an example. So if I take a child in a picture, and this child is being sexually exploited, and I run facial recognition against what we currently are talking about, driver's license photo and a booking photo, most children are not going to have those type of photos. And then the other thing is when we talk about time and expediency, when you start looking at photos, these, we can take an area, just for example, in Anne Arundel County, and look at it and use that tool to geofence, and we can see thousands of posts where people are trying to, basically pick up kids and traffic juveniles. So the open source is essential for us to be able to, have that access to be able to save time. And that's really what it's about. It will take us hours upon days upon hours to go through thousands of images and try to do it one by one in a current, situation with the facial recognition in this bill.
So, and you were on some of our meetings when I had asked exactly what was used in the mirror system, and it was explained to us that we used driver's licenses and mug shots, correct?
That's correct, yes. We When we had those discussions, we talked about the model system of which most agencies here use for the majority of crimes. We covered a lot of information there. I think it was lost in translation that we did mention other systems that were being used. But the issue was we really didn't have a whole lot of time to discuss it. And when we found out in December that the bill's provisions were going ahead and actually stipulating a single system, we really didn't have much discussion because we were getting close to legislation starting, and we weren't able to have those spirited conversations in person.
So how many other systems are being used by members of your organization?
That's difficult. I can't speak for every agency. I can speak about my agency, and we use the mirror system, cogent mugshot system.
So we're to understand that it's more than just the one system at the Fusion Center?
That's correct. So that's the cogent mugshot system, and then you have Spotlight, which they're using for human trafficking as well. And
Any other open sources that are being used?
Give me an example, just to make sure I can
Well,
answer correctly.
I think you had said that in your earlier testimony that you use open source information. And again, I understand law enforcement using systems and going on to things like Facebook and other things outside of them using it and pairing it with facial recognition technology. So what I'm trying to understand is, because I think all of us here, we've been lobbied by a company about its system. So I'm curious what other open source information or systems are being used in the state of Maryland.
So I can't speak about the specific system that you're talking about because I haven't been privy to how it's used or had access to it. I can talk about the ones that I do have access to, which is the state system, and as well as some of the human trafficking tools that we have. When you talk about, though, that particular tool, when you look at it again, it's the same thing as Spotlight. Unfortunately, our information is out there everywhere. And I hear what you said, Senator, about really the privacy debate versus not private. So I equate it to this, Senator. So if I do an image search, a web page comes up, and I can see everything. It's free game. It's public. I can see everything. But if you have a password, then I'm going to get a search warrant. If I can't see anything and we need to get in there, we're going to get a search warrant. So with the technology that you're talking about, again, it saves time. It goes and it matches photographs to other photos, which saves time. For example, in the Capitol, unrest, that would be an example where you would have a photograph of someone committing a crime. That's the only thing that you have because you don't have any identification, and you have to rely on that. We had a serial bank robbery here in Anne Arundel County. Had a pretty good facial picture. Guy went in, had a good face. We put it out all over the media. We didn't get any hits. We kept sitting there saying, why aren't we getting any hits of this? Gentleman lived in another state, came here, committed bank robberies, and then went back to the other state. So the only thing that we were left with is that picture.
And this bill, you think, would prohibit you from doing the search for somebody like that?
No, we could definitely use the current technology that we're talking about in the bill to do that. Against, again, the booking photos in motor vehicles. If that individual lived in another state, like I just told you, then what would happen is that we would not be able to make an identification of that individual if they had a Virginia driver's license because we're only getting access to Maryland, booking photos and MVA with the current system that we're talking about.
Is it possible to survey your members to find out how many systems are being used here in the state of Maryland?
Absolutely.
Thank you.
My pleasure, Senator. Thank you.
Excellent. Seeing no further questions, thank you both very much. Thanks.
Thank you.
All right, with that, I think that concludes the hearing for Senate Bill 762. We'll now move on to Senate Bill 750. Tamika's going to do, or is it, or Natasha, Ms. Mayhew, if you want to come up. So this is Senate Bill 750, and are you also doing 666 or just 750?
Just 750.
Okay, great. Come on up.
Good afternoon, Chair, members of the committee. Natasha Mayu here on behalf of the Baltimore City Administration in support of Senate Bill 750. I do want to thank Senator McCray for introducing this bill on the administration's behalf. So Senate Bill 750 will provide Baltimore City with the opportunity to strengthen our local towing laws and regulations in order to keep the city's transportation network free of obstructions. So it amends the city charter to explicitly allow for the authority to tow vehicles blocking driveways, alleyways, transit lanes, and then it ensures that we have open access to our city roads, alleys, and private driveways that are connected to our right-of-ways. It's a critical component of having reliable and efficient transportation network. Currently, only our police department can provide for towing of blocked driveways, and continuous parking regulation is preempted by the state law. So while there is some ability for DOT to tow vehicles, it's largely in the hands of the police department. So changes in state law are necessary for us to give that authority to our DOT. And so the towing authority in this bill will help us support local efforts to address those nuisance towing issues. We are aware that there is a proposed amendment from a private towers association. That proposed amendment would bring a significant change in how towing operations works in the city. Right now, we are only municipal towing, that's city-run through BPD and DOT, can tow vehicles that are blocking driveways, alleyways, et cetera. And so the proposed expansion would expand this authority to trespass towers, and those are the private towers. And so we just believe at this point it's important for this to remain within the city so that we have the appropriate oversight. Additionally, trespass towing, those changes would need to be made to the local city code, which is explicitly in the purview of the city council as they have passed the trespass towing laws. In conclusion, we just need this legislation in order to better address blockages of alleys, driveways, et cetera. And so with that, we do request a favorable report on Senate Bill 750 as introduced.
Thank you, Mr. Chair. I'm confused. I had always assumed that the Baltimore City Charter could only be amended by a referendum where the voters of Baltimore City would decide to amend the charter. Does the Maryland General Assembly have the power to unilaterally amend the Baltimore City Charter?
I can confirm. My understanding from our solicitor's office was that this bill could move forward and was necessary to address our issues.
Okay. You might want to go back and it just doesn't sound right. In Baltimore County, I'm positive that to amend the Baltimore County Charter, it would have to be an amendment submitted to the voters in public referendum. And I can't imagine that the General Assembly of Maryland could unilaterally amend the Baltimore County Charter without any buy-in from the people of Baltimore County. So that's my first question. The second question is, I assume you have a delegation letter supporting this?
So this bill, I'd have to double check with the delegate.
We have a letter.
Yeah, okay, there we go.
Senator West, I had the same question because the frame of reference for me was the Baltimore City Police Department. When we did that, it
Yeah,
had to go to
and they have to submit that to public referendum. Right.
Yeah, for the next election.
Exactly.
So we will look into it.
Okay.
All right, Senator Bailey.
So my question was, so I pull into my house and I'm in a hurry and I leave my car, I park across my own driveway and I run into the house to do something and I come back out. Is my car gone?
No, so these are for, the way the towing works now, and our understanding about the limitations here is that it often needs a citation or citable offense. So BPD, the police department, come out, cite, and then whether it's a BPD towing unit or they could ask for DOT to send their towing unit to tow the vehicle. We do want to ensure that this is, anytime a vehicle is towed, it's done properly and I guess in your example, what you're saying is you're worried that if your car is just outside of your driveway, someone will come through and tow. And that's not the intent here. The intent is when there's a complaint made and it's blocking access to those alleyways, those private driveways, we have a lot of like parking pads and other things, that those individuals would be able to file a request with the city to get the vehicle towed.
I just wanted to make sure that, we deal with this hawking issue, and I just wanted to make sure that we weren't doing something that was going to allow people, without going through the police department, without going through a complaint issue, that a tow truck could just come around, hawk it, and, hook it and be gone.
Right, and that was our concern with the amendment that was proposed. We expanded to private towers, and right now, we want to ensure, given the situations you've outlined, that still stays within government and that there's some oversight and process over it.
All right, thank you.
Seeing no further questions, thank you very much.
All right, thank you.
Thanks. With that, do we have any other witnesses for Charlie Parrish? Is Charlie Parrish still here? All right. With that, then that'll conclude the testimony and the hearing for Senate Bill 750. We'll now move on to Senate Bill 666, Senator McCray. And well, the bill number doesn't necessarily portend its future, so. All right. Yes.
Good evening, Chair, Vice Chair, members of the committee. My name is Tamika Winkler, and I'm here on behalf of Senator McCray to introduce SB 666. You all have seen this bill before in previous years, but this bill is slightly different. This bill is to establish clear anti-discrimination policies in public and non-public schools. The goal is to create a safe, welcoming environment for all children. I'm sorry. After that, I'm going to defer to the panel if you guys have any questions. I thank you guys for allowing me to present this bill. I'm sorry, I'm nervous. Thank you.
Good evening, Chair Smith, Vice Chair Waldstreicher, and members of the committee. I'm Sam Zwirling of the Maryland State Education Association, representing 75,000 educators across the state. We're here in strong support of Senate Bill 666, which we did not pick that bill number, and we hope very much that this can be the year that we get this across the finish line. Thank you very much to Senator McCray for his commitment to this issue and to Vice Chair Waldstreicher for his co-sponsorship. This bill is simply about providing every child with a safe and inclusive school environment, one that respects however they show up in the world. As Tamika mentioned, you've seen this bill before, but it is slightly different in response to some concerns in the past years. First, this bill explicitly covers prospective students. Second, it makes the same policies for public schools and publicly funded private schools. And it no longer asks the schools to develop their own non-discrimination policy and instead references federal Civil Rights Act and state law. This bill is about students. It's about students who are LGBT, students whose parents are LGBT. It's about students with disabilities. It's about making sure that any state-funded institution is safe for all. The acceptance of public funding by a non-public school is not mandatory. It is voluntary. And if there are schools that do not wish to abide by these policies, they can either not engage in discriminatory practices or choose to not accept public funding. These requirements of this bill are not new to any recipient of public schools, of public funds. Public schools are and have long been aware of the requirements to adhere to federal and state laws, and in this case, as it specifically relates to prohibitions against discriminatory practices. At the end of the day, this legislation is really just about ensuring that no student in a publicly funded school is discriminated against. We urge a favorable report on Senate Bill 666. Thank you.
Good evening, Mr. Chairman, members of the committee. I'm Ann Seacott, and I'm speaking today in favor of Senate Bill 666 on behalf of Disability Rights Maryland. Disability Rights Maryland is part of a large statewide coalition called the Education Advocacy Coalition for Students with Disabilities. You have the written testimony. The one piece I would really like to make clear about this legislation when it comes to prohibiting discrimination against children with disabilities is two things that the bill isn't, that it doesn't do. It does not mandate that every student with a disability, no matter how severe, must be admitted to and served by a non-public school from which the student's parents seek enrollment. It also does not provide all of the services to a student with a disability that they could get under law if they were going to a public school. So what the bill does is say that reasonable accommodations must be made for students with disabilities. And, you know, just very practically speaking, what that means is accommodations are things like longer time for taking tests, perhaps leaving classroom a couple minutes early because they have difficulty walking down the hall and need a couple of extra minutes. There are many, many, many accommodations that cost $0, and those that cost any money usually cost in the range of maybe a few $100s at most. This is not requiring IEPs. This is not requiring every school to develop a special education division and special education teachers. This is about things that are very reasonable. And to that effect, we had a conversation a few weeks ago with some of the non-public schools who have concerns about the disabilities issue. And there should be an amendment. If we might have requested it late, it's on the House side, but an amendment to clarify which federal laws we're talking about apply. So the amendment will specify that the federal laws that we're talking about with regard to reasonable accommodation is Section 504, some of you may be familiar with that, and the Americans with Disabilities Act, not the Individuals with Disability Education Act that is the IEPs and the rest of that. So with that, we ask for your support for the legislation.
Good afternoon, Chair and esteemed members of the committee. My name is Jeremy Lemaster. My pronouns are he and they. I'm the Executive Director at Free State Justice, a 30-year-old legal services and policy advocacy organization for low-income, lesbian, gay, bisexual, and transgender Marylanders. Today, I am here in favor for HB 850. Growing up, I was a low-income student of a single-parent family. I grew up amongst a housing project. I also received financial aid in order to attend a private school. I went to a private Catholic school for 12 years. I received hot meals through public funding. I've received Pell Grants to go to college. I would not be the person I am today without that financial support. That being said, if as a child I had a choice, I would have chose to attend a school that was safe and had policies and protections for queer kids like me. As a queer student, I did not have a safe learning environment. I learned in constant fear. I lost years of my life digging out of the trauma experience during those times growing up. My school did not have policies like the one being proposed in HB 850. In best case scenarios, students like me exist in a don't ask, don't tell environment. We see now nationally, even today, people are being banned from saying the word gay. If we no longer require our military to operate under these conditions, then why do we ask our children to? HB 850 would allow Maryland to join 18 other states that have adopted non-discrimination policies for their schools. It would implement a published policy, which as research shows is the single biggest improvement to school environments. It reduces absenteeism, it reduces bullying, and it overall improves safety and well-being. Grades are improved. Additionally, research shows that learning outcomes for Black and brown students, for girls, for disabled students, for immigrant students, for LGBTQ students, and low-income students all benefit from non-discrimination policies. Kids like me don't have a choice where they are born, how much money their family makes, or where they get to go to school. It is our duty as adults to protect all kids everywhere. This bill is simple. Public funds should go to non-discrimination policies that ensure that all students have safe learning environments, period. I urge a favorable report on HB 850. Thank you. Senate bill, oh my goodness, thank you. Senate bill 666. It's a long day.
Good afternoon, Mr. Chairman and members of the Judicial Proceedings Committee. My name is Alyssa Dangle, and I'm a sixth grader in Western Howard County. I'm here in support of Senate Bill 666, which bans discriminatory behavior towards students in schools. The issue matters to me because I have a friend who's LGBTQ IAP+, and many people intentionally use the wrong pronouns and use slurs to be cruel and demeaning. When people are like this, we need help, but there are no easy or reliable ways to get the help we need. The few teachers we are able to ask undermine situations by saying that people are getting used to it, and if we give them some time, they will get pronouns right. But there have been 2 years and nothing has improved. If this law is in place, we will get the support we need, and we will know what the best next steps are. With this bill, many people can get adequate and reliable help. I'm testifying for this bill to help students if they are discriminated against for their race, ethnicity, religion, for being disabled, or if they are discriminated against for being LGBTQ IAP+. These actions are caused by some gaps in the Maryland education law system because of patchwork laws that don't protect all students from harassment. There just aren't strong enough Maryland laws to cover this use of cruel language. Even staff members can be discriminatory. There are neither statewide protections nor a good help system, and the effect is lower academic performance, lower GPA, increased absences, increased likelihood of school dropout, more psychological distrust, and a decreased likelihood of attending higher education. This bill is needed now. This time has to be the term because some students need help immediately. We need to pass this bill to help students who need it and to stop the discriminatory comments before they hurt more students. I'm speaking here for students who need this bill because if all students who'd benefit from this bill were here, there wouldn't be enough seats. Please pass Senate Bill 666.
Well, it's been a long, long day, but your testimony was worth it, Alyssa, so thank you for coming down. All right, we'll go to committee for questions. Senator Sidnor.
Thank you, Mr. Chair. How is this bill different from the bill from last year?
Yes. So the bill, we did make some amendments. First, as Ann referenced, there was an amendment that should be coming in your packets related to clarifying some of the disability accommodations. Second, this bill explicitly covers prospective students or students that are applying to some of the non-public schools. The bill last year kind of created a two-tier system between the publics and the non-public schools. So this makes a blanket coverage for all types of schools. And it no longer asks the schools to develop their own non-discrimination policy, and instead just references the Federal Civil Rights Act and the appropriate state laws.
That latter piece, that, if I remember correctly, last year, that was one of the issues that the Orthodox. Thank you.
All right, additional questions? Excellent. Thank you. Senator West.
I don't know if we have opposition testimony to be given this afternoon, but in light of the fact that strong opposition was registered by the Maryland Catholic Conference, by Agudath Israel of Maryland, and by the Council for American Private Education, I thought I'd ask one of the proponents to respond. Let me just single out one comment. This is the Agudath Israel testimony. It said this bill puts the foundation of parochial education under serious and unprovoked threat, and presents insurmountable challenges that are not culturally or fiscally sustainable for nearly any of the participating non-public schools. Would someone like to respond to those allegations?
I can begin, and then if any of my colleagues want to chime in. This bill does make a couple of explicit accommodations for those types of schools. It first says that if there is a historical reference or a historical precedent for it being a single-sex school, an all-boys school or an all-girls school, they don't have to then admit students of that different sex. It also, the accommodations, as referenced by Ms. Seacott with Disability Rights Maryland, we're talking about things like extra testing time, things like that. And I believe all of these things that we have in the bill here are things that these schools have to sign as assurances through the Boost program or other things. So they're already signing these. We are just putting that into state law to participate in the program.
And if I could just add, the other accommodation or exemption in here is also for religious schools. So a same-sex school, certain religious schools, not certainly every single religious school, but certain religious schools are also exempted from the requirements. Go ahead.
And I'll just add to that too, I think when it comes to religious schools, it's really just not requiring or mandating any type of instruction. So for example, I went to a Catholic school. We had Muslim students, we had Jewish students, because they still would like to get a Judeo-Christian religious education. This bill is not changing curriculum or requiring that different religions be taught or that a religion can't be taught in those school settings.
And the one last thing I'll just also add to that is that, as we mentioned earlier in the testimony, if some of these schools feel like the things in this bill are too onerous, it is voluntary to participate in some of the publicly funded programs. And so, it's not the same as, the public schools that, can only get their funding from one place and so have to comply with all of those other provisions.
Thank you. Ms. Seacott, could you just elaborate on what you said about there are certain changes for the religious schools?
Sure. And this is not new from last year.
Okay.
On page 3 of the bill, lines 27 through 31, you'll see that it says, if a school only admits and teaches, very specifically is a school that teaches a specific religion, that they are exempt from. So the subtitle does not apply to, that first section is about same-sex schools. The second one is about certain religious schools. The third one is about disabilities as long as reasonable accommodations are being.
Yeah, and I would just kind of, again, add to that, for example, a Muslim student can't just go to one of these schools and expect to be taught in their religious tradition, right? It's not mandating that the school change what they're teaching in terms of their religious tenets.
Okay.
So that's why the exemption exists, so someone can't say that. Yeah.
Right, so an Orthodox Jewish day school is not going to be expected to change their curriculum for somebody who's Catholic who decides to matriculate there. Okay, thank you.
Any other questions for this panel? I was up in finance, but just wanted to thank you for bringing the bill. I'm proud to be a co-sponsor, and discrimination against gay and lesbian, LGBTQ members of our community in public schools or in private schools that take public money is certainly not acceptable. So thank you again for bringing the bill. We'll bring up the next individual, Mr. Piniella.
He wasn't able to make it. He had childcare issues.
Understood. Yeah, today's been a strange day schedule-wise, so we thank everyone for their flexibility. That has affected all of our hearings today. Okay, and that concludes the hearing on that bill. Thank you again for bringing it. The final bill today before we vote is Senator Watson, Senate Bill 884.
Thank you, Mr. Vice Chair. Good evening, committee members. I'm here to present Senate Bill 884. This bill exempts an obligor whose income is at or below 300% of the federal poverty level from provisions requiring the Motor Vehicles Administration to suspend the obligor's license or privilege to drive in the state if the obligor is out of compliance with child support order and specified conditions are met. Current law right now states that after providing an obligor with notice and the opportunity to request an investigation as specified, the Child Support Administration may notify MVA if an obligor is 60 days or more out of compliance, or 120 days for holders of a commercial license. That distinction by itself recognizes that there's more more attention given to somebody who has a commercial license, with the fact that they have a job. And that time that they have to cure an obligation is double that of someone else. That's an issue. And so, in 2015, NPR reported that 62% of Marylanders who owe child support make less than minimum wage, but owe at least $10,000 in unpaid arrearages. They'll never pay down the debt, especially when the current law magnifies the issue by crippling their mobility. There's a federal code that demands that all states have laws that increase the effectiveness of the child support enforcement program, which the state administers, and follows the state to withhold, suspend, or restrict licenses of individuals owing child support in appropriate cases. However, our current suspension practices may have already left us out of compliance, since we are effectively preventing lower-income obligors from the employment needed to pay their obligations. As such, Maryland should pass Senate Bill 884 to repeal driver's license suspensions as a penalty for obligors who make less than 300% of the federal poverty level. And let me just let you all know, that's about $39,000. The average salary, according to my research, for Marylanders who own commercial driver's license is $50,000, and my cursory search through Indeed as high as $85,000 for those folks who drive with Amazon. So this is certainly out of compliance. I have some experts here as panelists. I ask for your respectful, favorable committee report on SB 884. Thank you.
Members of the committee, my name is Christopher Dews. I am the Senior Policy Advocate of the Job Opportunities Task Force, where our mission, as always, is to help lower-wage workers advance to higher-wage jobs. For us, this is an employment issue. Without a driver's license, it's incredibly difficult to obtain and sustain employment. 50% of Maryland's workforce travels to another county for employment, according to the U.S. Census Bureau, and only 9% of the jobs in the Baltimore region can be reached within 1 hour one way by public transit. So if you're going to really work in this state, you're going to need a valid driver's license as well as a vehicle, and auto insurance for that record. More recent numbers than what the senator had just mentioned, 50% of Maryland obligors were not employed. 50% of Maryland obligors were not employed in 2017. 43% earned minimum wage or less, but owed on average $10,000. So I just put that number out there simply to say that when you don't have a job, paying your child support is incredibly difficult, and we need to be able to distinguish between the difference between somebody who is dead beat and just trying not to pay and somebody who is dead broke. Therefore, we believe that this bill, focusing on 300% the federal poverty line, is going to hit lower income obligors. And for the record, this is not affecting the ability to garnish wages. It does not affect the ability to incarcerate, actually, for contempt of support. This is simply removing one tool from the toolkit to ensure that lower-income Marylanders do not have a massive barrier to employment. As a person who's run a workforce development program, I used to hire people all the time, and the biggest barrier that they had to transit when I was working in Baltimore City was the driver's license because it was suspended. As I said, 9% of those jobs can be reached within 1 hour one way by public transit, which means 91% could not. I had to deny many people the opportunity just to get trained for employment because their licenses were suspended for their inability to pay child support. So for those reasons, we do urge a favorable report. I just want to acknowledge one thing that you're going to probably hear. The notices that are supposed to go out are very rarely sent. You'll see that in law. Work-restricted licenses are also very rarely even used. So because of housing intransigence, the bottom line is we need to pass this bill and remove this specific tool to help out Maryland workers. Thank you for your time.
Members of the committee, thank you for the opportunity to present testimony in support of Senate Bill 884. My name is Eliza McDermott, and I am a University of Baltimore law student and a Rule 19 student attorney in the Civil Advocacy Clinic, where I represent low-income individuals under the licensed supervision of Professor Dan Hatcher. We're proud to support SB 884 because it will support work, not block work. This bill is needed to reduce harm to low-income children and families. The current license suspension policy makes it even harder for non-custodial parents to work and pay child support, prevents non-custodial parents from driving their children to school, doctor's appointments, or other needed trips, and exasperates systemic poverty and racial inequality through the disparate negative impacts on Maryland's Black families. For example, license suspensions in Maryland have a disproportionate racialized harm. Black Americans constitute roughly 31% of Maryland's population, but between the years of 2015 and 2020, they represented 71% of those whose licenses were suspended. Also, and importantly, SB 884 is consistent with federal law. Federal law simply requires that each state has, and uses in appropriate cases, authority to withhold or suspend driver's licenses of individuals with overdue child support payments. This bill should be construed as consistent with that federal requirement. I therefore submit this testimony in support of a law that supports work, not blocks work, and respectfully request a favorable report.
Do I get the extra 7 seconds since she didn't use it? Just kidding. Good afternoon, Chair, Vice Chair, although I don't know if the Chair, good afternoon, members of the committee, whoever's still here. I know it's been a long day. My name is Stacey Bensky, and I'm a family law attorney at Maryland Legal Aid. So you might read Family Law Article 10-119 and think, why another exception? Why, if we already have enumerated exceptions in the law to stop license suspension, if it would impede employment, or if the obligor is disabled, or if the obligor is paying on their arrearage balance per payment agreement? Well, unfortunately, the Maryland Child Support Agency uses an automated driver's license suspension system that operates as if those exceptions in the statute do not exist. Their automated system does not remove obligors who fit into those enumerated exceptions from the pool of people who can be selected for license suspension each month. So the only thing that stops an obligor from being in that pool of people who might get their license suspended is if they get their arrearage balance down to less than 2 months of arrears. So until that happens, they can be repeatedly selected for suspension. So I have many clients who need their driver's license for employment, and they are employed, and they pay extra towards their arrears each month by earnings withholding order. So they pretty clearly fit into 2 of those exceptions already in the law. Still, month after month, they are continuously selected for license suspension. So I'll have their license reinstated, and then a few months later, I'll get a call from the same client. My license is suspended again. This could be easily remedied by suspending driver's licenses only when appropriate on a case-by-case basis, and that's what the controlling federal law says. It says that state agencies have the authority to suspend, quote, in appropriate cases. Driver's licenses, and if I can just, my one last thought, I apologize, that driver's license suspensions are not appropriate or effective for someone living in poverty. It's an obvious barrier to employment, and it harms the entire family. It's harder for a non-custodial parent to be an involved parent if they don't have a driver's license, and it essentially punishes entire families for being poor. So for those reasons and many others, we would urge the committee for a favorable report, and we hope that the law is correctly implemented by the agency.
Thank you so much for your testimony. I appreciate it.
Okay, thank you. And I'm happy to answer any other questions about that implementation if there are.
I think they call a different panel. Okay. I think there's, yeah. Yeah, go ahead.
Oh, I apologize. I wasn't sure. I'm favorable with amendment, and I wasn't sure if that was called separately.
Go ahead.
Oh, thank you. My apologies
Sorry.
to the committee. Again, Lindsay Parvis from the Maryland State Bar Association, Family and Juvenile Law Section. We support this bill for the reasons stated, so I will not repeat those. We do have an amendment, though, that we are requesting, so favorable with amendment. And our requested amendment goes to the exclusion not applying to those obligors who have already been judicially determined in a court proceeding to be voluntarily impoverished. So I invite this committee's attention to 12201 of the Family Law article, which discusses voluntary impoverishment, defines that as a term, and in fact, The language that will become effective July 1st of 2022 is really the reference point for that voluntary impoverishment language. Thank you.
Okay, questions from the committee for this panel? All right, thank you all very much. Thank you. Thanks for hanging in there with us. It's been a long day and night. There's Nicole Hanson-Mundell here.
All other witnesses had to.
They all bounced. Okay, got it. Thank you very much.
Thank you, sir.
So is that it? All right, well, then that will conclude the hearing for Senate Bill 884 and the hearings for the day. We are going to, we have to do a quick voting session. We're going to vote on 2 bills, and then we're going to come back tomorrow morning at 9 a.m. to vote. So we've got 9 to floor to vote. So this shouldn't take long, but let's take we'll take a 10-minute recess and come back and hopefully knock this out.